Welcome to the Adakay Show. I'm your host, Adakay, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Good morning, everybody. We are hopping in from another trial right now. We are in the Alicia Andrews trial, and we are hopping over here to this trial. We're going to be catching up on day 3 and 4 when this trial is over, and I am looking forward to getting back into this. So, now I'm getting doing 3 things at once. Sorry, I'm trying to. So we are coming to this part. We're going to day 3 and going into day 4. Thank you, guys. The other kids, they are arguing the point. Yeah. Oh. All right. Recap real quick. Change. Up children. Not talk to them. 2, 1 entry and 1 up here and exited the right eye. There was 3, 4, 3 people. Good job. Had an apple. Reviewed. Right hand. And indicators of the thinking was deliberate, not was root in immediate danger. Defensive strategy acted out of fear and was to take the brain real and not now. What's next? That for be watching you restricted welfare and cycle. I am going to go ahead and get that video up, and I will figure out it's on stand in a minute, and then I'll get that. Sure. Comment. All righty.
I'm going to ask, if you haven't already done so, if you can pull that microphone a little bit closer to you. Thanks so much. Sir, what is your current employment?
I'm employed. I'm a detective sergeant with New Hampshire State Police assigned to Troop C.
And how long have you been working with the New Hampshire State Police?
Sorry.
The state will call Sergeant Michael McLaughlin.
So, Michael. Forgive me. Come on. Thing.
I'm a detective sergeant with New Hampshire State Police assigned to Troop C.
Sergeant McLaughlin, if you can remain standing there, please raise your right hand. Do you swear that the testimony that you're about to give is the whole truth under penalties of perjury?
I do.
Can you lower your right hand and be seated? Sergeant McLaughlin, I'm going to ask, if you haven't already done so, if you can pull that microphone a little bit closer to you. Thanks
How's
so
that?
much. Sir, what is your current employment?
I'm employed. I'm a detective sergeant with New Hampshire State Police assigned to Troop C.
And how long have you been working with the New Hampshire State Police?
15 years.
How long have you been assigned to Troop C?
15 years.
Dr. Weinberg, could you raise your hand?
Yes, sir.
Do you swear that the testimony you're about to give will be true under the pain and penalty of perjury?
Yes.
Thank you. Please have a seat.
I'm not having a pen.
Good morning. Could you please introduce yourself to the jury and spell your last name?
Sure. My name is Mitchell Weinberg. Last name is spelled W-E-I-N-B-E-R-G.
Dr. Weinberg, where do you work?
I work at the New Hampshire Office of the Chief Medical.
State, I did look to see what was going on in the Berlin case. But I was at the barracks. We monitor Keene Police Department's radio as well as Cheshire County's radio at the barracks. There was some commotion It's in another room, so I didn't totally hear what the transmissions were. But at some point, my lieutenant popped his head into my office and said that the vehicle from the Amber Alert is at the Applebee's in Keene.
Once you heard that, what did you do?
My first reaction is, no, it's not. But after a few minutes, I decided it would probably be best, again, being the closest detective, to head over there and verify that, because I knew.
I'm trying to get everything balanced. So.
Just
Give me a minute.
fully getting set up here, and
What's going on?
I'm a detective sergeant with New Hampshire State Police assigned to Troop C,
There we go.
And how long have you been working with the New Hampshire State Police?
15 years.
How long have you been assigned to Troop C?
15 years.
Did you have law enforcement experience prior to joining the New Hampshire State Police?
I served in the military as a military policeman for 14 years.
As a sergeant with the New Hampshire State Police, what does that mean your responsibilities are?
So a detective sergeant with the state police, I have 2 detectives assigned to me, so 3 of us total. We're assigned to Cheshire and Sullivan counties, responsible for the more serious crimes, burglaries, thefts, sex assaults, all the way up to and including homicide, assisting major crime.
When you say assisting major crime, what do you mean by major crime?
So major crime is basically what most agencies would call a homicide unit or homicide investigative unit.
And as part of your responsibilities as a detective sergeant with Troop C, or as a detective in general with Troop C, you assist the major crime unit if they need help with those kinds of investigations?
Yes.
Okay. Now, do you have any kinds of training or experience that you utilize during your job with regard to conducting investigations?
Yes.
What kinds of training do you have?
So I have basic investigative trainings. I do have training in homicide specifically. On a death investigation specifically, I do have training in interview and interrogation. There's a lot more training and experiences.
Well, let me ask you about that. You said that you had trainings with respect to interviews and interrogation. Are those 2 things interchangeable, or can you explain to us what the difference is between the 2?
Sure. And this is more my definition based on my experience, but interview, I would say the person that is being interviewed would do the majority of the talking. Interrogation, on the other hand, would be, the investigator would be doing most of the talking. Interrogation is more direct questions as opposed to an interview that would be open-ended questions, and the suspect would be given the opportunity to, or the interviewee would be given the opportunity.
Time. So both lives at one time. I'm going to say this. The live with the Alicia Andrews, when we're done with that, you will teleport over to the Amber Alert Red Room trial. You should automatically, just FYI, but the other one is up and running.
opportunity to answer those questions.
Do you conduct interviews of suspects or interrogations?
Generally, or mostly interviews. Occasionally, it does turn into an interrogation.
Did there come a time when you became involved with an investigation that was being conducted by the Major Crime Unit into a homicide that occurred on February the 29th of 2024 in Berlin, New Hampshire?
Sorry to pause, everybody. They ended trial, so this one is done. We are done for the day on this trial. Please keep up with us on Monday. We'll be back live again for the Alicia Andrews trial. We will do the bingo drawing on the other feed. So all the drawings will go. We're going to teleport over there at the end of the day. I'll do the drawing for both feeds. Please make sure you comment, like, subscribe, and put all that in the comments below. You know what to do, the YouTubey thing, so you too can possibly earn some free merch. Thank you so much for joining me today in the Alicia Andrews trial. We will now see you over in the Amber Alert trial. See you in a minute. We're now live. Alert. Dustin Duren. Good to see everybody. We are starting off our trial today with Sergeant Michael McLaughlin, and he is going to be speaking about his investigation and what he did and all that good stuff. Other than that, let's get into court.
Yes.
And I guess let me back up. Troop C, what areas of New Hampshire does that cover?
So it's Cheshire County and Sullivan County. So the southwest section of New Hampshire.
Where are the barracks for Troop C located?
Keene, New Hampshire.
Where in Keene?
15 Ashbrook Court, which is right off of Route 9.
How far from, let's say, the Applebee's in Keene is your troop barracks?
It's one intersection away. It's less than a mile.
What was your role in the investigation that you became a part of, the one that happened in Berlin?
So initially, I was the closest detective to a traffic stop that was ongoing. And then eventually I was assigned to conduct an interview with Mr. Duren.
Now, can you explain how it is that you actually did become involved? You said you were the closest detective. How did you become aware of this traffic stop that was occurring?
So before that, I was aware of the death investigation for two different ways. So I received text messages for all death investigations in the state. So I was aware that there was a death investigation in Berlin in the early morning hours. I also received an Amber Alert, which added to that. When I signed on for duty that morning, it was 7:30 that morning, I signed on for duty. State Police has a computer dispatch program, and I'm able to see what's going on in the entire state. I did look to see what was going on in the Berlin case. But I was at the barracks. We monitor Keene Police Department's radio as well as Cheshire County's radio at the barracks. There was some commotion. It's in another room, so I didn't totally hear what the transmissions were. But at some point, my lieutenant popped his head into my office and said that the vehicle from the Amber Alert is at the Applebee's in Keene.
Once you heard that, what did you do?
My first reaction is, no, it's not. But after a few minutes, I decided it would probably be best, again, being the closest detective, to head over there and verify that, because I knew my phone would be ringing eventually with questions. So I drove to the Applebee's and ultimately verified that it was the correct vehicle.
Okay. And when you arrived at the Applebee's, what did you see? What was happening?
So there was a Keene police cruiser. I recognized the white Subaru from the Amber Alert, so I noticed that was parked. The Keene cruiser was not far behind it. There were several other Keene cruisers, a lot of officers and state troopers at that point, and some other people in the area. What I did was I spoke to the Keene officers, and my lieutenant was at the scene, determined that Mr. Duren was in the back of one of the cruisers, and just briefly introduced myself, expecting to have a further conversation with him later on that day.
Okay, when you say you introduced yourself, you approached Mr. Duren and you indicated, did you introduce yourself, say who you were?
I did.
Okay, and did you ask him any questions at that point?
Basically, like, is he okay? Is there anything I can get him? Is he comfortable? And just said that he would most likely be coming to the Troop C barracks in Keene, and that we would have a lengthy conversation once he got there. What I do recall is the heat, and I felt it myself, but the heat inside the Keene cruiser was on very high, and Mr. Duren asked if I could have the Keene officer adjust that, which they did.
Now, you have looked several times towards a location in the courtroom when you say the name Mr. Duren or Duren. Do you see Mr. Duren, the person that you introduced yourself to that day here in this courtroom?
I do.
Could you, by pointing him out and/or identifying him by an article of clothing that he's currently wearing, please let us know where he is?
Sure. He's seated right here, almost directly in front of me, wearing a gray suit. We'll call it a purple shirt and a paisley purple tie.
Your Honor, identifying the defendant for the record.
The record shall so reflect.
Now, when you see the defendant here today in court, does he appear to you to be does he look the same as he did when you first met him?
He's got a haircut. His beard is a little shorter, but he does look the same.
Showing you what is marked for identification purposes is State's Exhibit 18 for this case. Can you take a look at that and let me know if you recognize it?
I do.
What is it?
It's a photograph of Mr. Duren.
Okay, and does that photograph clearly and accurately show Mr. Duren at the time that you met him on March the 1st of 2024?
Yes.
So at this time, the state moves to strike the identification and admit State's Exhibit 18 as full.
No objection.
The ID shall be stricken and Exhibit 18 shall be considered a full exhibit.
Permission to publish, Your Honor?
Certainly.
We're replacing, let me plug in first. Currently publishing State's Exhibit 18 on the screen. That's how Mr. Duren appeared when you first encountered him?
Yes. Yes.
Now, you've described to us your first interaction with the defendant, how you introduced yourself to him and asked to get the heat turned down for him. Why is it that you went out to the scene and introduced yourself to him?
I would describe it as building rapport. Again, just making sure he was comfortable, and when we did get a chance to sit down and talk, I did essentially the same thing, but just make sure he's comfortable. If he needed to eat, we would get him some food. If he wanted something to drink, we would get him something to drink.
At the time that you met him at the Applebee's parking lot when he was in that cruiser, did you ask if he wanted any food?
I believe so.
Okay. Did at that time he ask for any?
For food, no.
Okay. How about for anything else?
I believe I told him that I make a good, strong cup of coffee, and we had a discussion about that, and eventually he did accept a cup of coffee.
Did you later make arrangements for him to be interviewed at Troop C?
Yes.
Can you describe for us the location inside of Troop C where that interview occurred?
So there's several entrances to Troop C, which had been renovated not long before this incident. There, to the far left of the building, there is a garage door, and just to the right of that is an entrance. Just inside that entrance to the right is an interview room.
When you say an interview room, can you describe for us sort of how large that is? What's in there?
So it's probably a 9 by 8 size room. It just has a round table with 3 chairs in one corner. In the opposite corner, it has a desk with an office chair and then a separate chair.
When you sat down to interview the defendant, Mr. Duren, who else was present, if anyone?
So Detective Horton, who works with me, eventually was present in the room as well.
This interview that you conducted of the defendant, Mr. Duren, was that audio and video recorded?
Yes.
Can you describe the manner in which that occurred?
Sure. So again, the barracks is newly renovated. We do not have an ideal recording system. So in this particular case, an audio recorder, just a handheld audio recorder, was placed in the room, and then I used my state-issued cell phone to video record the interview.
Was the defendant, or did the defendant consent to this interview being recorded?
He did.
Now, with respect to the interview itself, did you have any interruptions with respect to the recording?
One interruption was it's recording on my state cell or my cell phone. Not long into the interview, the cancellation of the Amber Alert, which is that loud, annoying sound that the cancellation of that came through the phone, which turned off the video recording.
Okay, so there may be a snag or a delay when the video is playing, is that
Yes.
fair to say?
Yes.
Okay. Now, have you reviewed the video and audio recording of this interview that you conducted with the defendant in preparation for your testimony today?
Yes,
Did you also review a copy of the transcript of that recording?
I did.
Showing you what's marked now for identification purposes only as State's Exhibit 27. Can you just take a quick look through that? And let me know if you recognize it.
I do.
What is that?
This is a transcript of the audio recording.
Now, with respect to the transcript and the audio recording, did you review those together in order to determine if they were fully accurate?
I did.
Okay, and can you tell us if there are any errors in the transcription?
There are some.
How would you classify those errors?
So there are occasions where I'm speaking, but the text is attributed to Detective Horton. There are also some other where the audio might not be totally perfect. For example, I say the word Keene, referring to Keene Police or the city of Keene, and the transcription says Keith. There's one other that I can think of where we had a conversation about racking around in a pistol, and it says whacking instead of racking.
Okay, so like some word changes, but the video and audio is accurate to what was said. Is that
Yes.
fair to say? Okay. Now, after
Okay, I gotta,
you were in the room and you had, and I'm gonna come grab that for you while I ask this question. But after you were in the room and you had your cell phone set up, your recording was going, did you talk to the defendant about his Miranda rights?
I did.
And can you explain for us what Miranda rights are?
So it's his rights to his right to speak to an attorney, his right to answer questions, his right to not answer questions, and just that he could stop answering questions at any time.
Fair to say that advisement we've probably all heard on TV and Law and Order and all those other shows that just are everywhere?
Yes,
Okay. Now, when you conducted that procedure here, is it fair to say that you utilized a form?
I did.
Is that customary?
Yes. Doesn't have to be a form, but that's what I use.
Sergeant McLaughlin, I'm showing you what I've marked for identification purposes as State's Exhibit 25. Do you recognize that form?
I do.
What is it?
This is it's a State Police DSSP 105, New Hampshire State Police DSSP 105 form, which is a Miranda rights form.
Now, when you say DSSP 105, does every form within state police sort of have a number assigned to it?
It does.
And that's where the DSSP 105 is?
Yes.
Okay. But this is a form that you utilize to go over Miranda?
Yes.
In this particular form, do you recognize it in terms of being the Miranda form or waiver form that you went over with this defendant, Mr. Duren?
I do.
And is that a fair and accurate copy of the form as you completed it with Mr. Duren?
Yes.
Your Honor, at this time, the state moves to strike the identification on states 25 and admit it into evidence as full.
No objection.
The ID may be stricken with respect to Exhibit 25, and it shall be considered a full exhibit.
Can you describe the process, and if you need the form back, let me know, but can you describe the process by which you provided Miranda to the defendant?
So I read each line, you know, for example, line 1 is you have the right to remain silent. Typically I'll ask, in this case I asked Mr. Duren, do you understand that right? He would say yes. I put a little check mark next to that, line 1. I would read line 2 and same thing. Then I do add a little bit where I explain if you start answering questions and you decide for any reason you don't like a question or you don't want to answer a question, we can skip a question and move on, which he said he understood.
I've been sitting here with the camera off. My bad.
And then I asked him to, so I write yes next to, do you understand these rights? And I asked him to initial that after I handed the form to him. And then I asked the second question, which is, understanding these rights, are you willing to answer questions? He said yes. I wrote yes, asked him to initial that, and then sign the form. And then Detective Horton signed the form as a witness to Mr. Duren signing.
Now, by signing the form, is that the defendant indicating that he understood his rights as they were read to him and that he was willing to speak with you?
Yes.
Now, in addition to signing, and without telling us what, if anything, was said, did the defendant make statements to you during this interview that confirmed that he understood his rights?
Yes.
After the Miranda process, did you continue speaking with this defendant?
I did.
Can you describe the manner in which this interview was conducted in terms of interview versus interrogation and how it began?
So Mr. Duren was, I formed the opinion shortly after meeting him at inside the King Cruiser that he was ready to talk to someone about what had happened. I would describe Mr. Duren as being very talkative that morning or afternoon. And he actually had some questions initially as well. And I had some questions that I was asked to ask about the children. So we started the conversation with basically answering Mr. Duren's questions.
Now, during the course of this interview, was the defendant again offered food and drink?
He had water and coffee before we started the interview, and I think we got him a sandwich after we finished.
If he had asked for a sandwich earlier, would you have provided that?
Yes.
Was he allowed to take breaks or use the bathroom?
Yes. Yes and no, because he had used the bathroom before, and then we kind of gave him the opportunity. We asked about using the bathroom before we concluded, and Mr. Duren actually decided, let's get through the questions and then use the bathroom.
During this interview, while you were speaking with Mr. Duren, what kind of tone of voice did you use?
Pretty much what I'm using right now. Just normal, my normal self.
And what about Detective Horton? What kind of voice did he use?
Detective Horton is a little louder in general. He just speaks very loudly, but
Robust.
his normal voice.
Did anybody yell or scream at the defendant?
No.
Did at any point you use aggressive body language or aggressive gestures?
I don't believe so, no.
At any point was your service weapon involved?
No.
Now, who spoke more during this conversation, yourself or the defendant?
The defendant.
And who led the conversation, yourself or the defendant?
The defendant, but I tried very hard not to interrupt, but there were times where we had to kind of get the conversation back on track.
Now, following the interview of the defendant, was there a search warrant process that was conducted?
Yes.
Can you explain the purpose of that process?
So it's a search warrant, we call it a body warrant, so there's a collection of a number of evidence. The photo that is still on the screen, so there's a number of photographs taken to document injuries or the lack of injuries. Oops, I guess I'm not supposed to talk about that.
No, it's all right.
So we take some photos to document injuries, non-injuries, any evidence that might be on Mr. Duren at the time. There's swabs for different things. So a DNA swab would be basically a Q-tip that goes inside of his mouth to collect cells from inside of his cheek. There would be typically gunshot residue swab to his hands. There would be fingerprints, sometimes a collection of fingernails, sometimes a collection of hair, and essentially in the collection of his clothing.
Is that customary to every homicide investigation that you've worked?
Yes,
Now, in addition to collecting items from his physical person, were items of his personal property recovered?
I believe there were some items from the vehicle and some items from his person. I believe his wallet was one of those things.
Okay. Was his clothing also recovered?
His clothing was collected, yes.
And was a cellular phone recovered?
I believe so.
And you indicated that his wallet and identification cards were recovered?
Yes.
Sergeant McLaughlin, I'm showing you what is marked for identification purposes as State's Exhibit 31 in this case. Do you recognize what that is?
I do.
What is it?
It's a temporary New Hampshire driver's license.
Okay, is that a particular person's driver's license?
It's Mr. Duren's.
Okay, and was that recovered from him during this search process?
Yes.
Your Honor, at this time, the state would seek to strike the ID and admit State's Exhibit 31 into evidence.
No objection.
The ID may be stricken with respect to Exhibit 31, it shall be considered a full exhibit.
Permission to publish.
Certainly.
Sergeant McLaughlin, I've placed State's Exhibit 31 up on the screen. You still have a copy with you. You also have a screen to look at. Does,
Sidebar.
We got nothing but a sidebar. Let's see if I can kill the fly on the mic. Did I get it? I did. Now it's on the keyboard. Dead fly. Don't bother me. Shoot die. Don't bother me. Fly. Don't bother
set?
me. Hello.
Sergeant McLaughlin,
All
with
set, excuse me, all
res-
set, Counsel?
Yes.
Okay, thank you.
Sergeant McLaughlin, with respect to State's Exhibit 31, which is on the screen, on all the screens, as well as in front of you, does that driver's license indicate what Mr. Duren's height and weight are?
It does.
And what were those?
His height is 5'10" and his weight is 190 pounds.
Yes, one of my social media people asked me.
Sergeant McLaughlin, before we publish or talk about further the
Okay, guys, let me do some explaining for the new people because I am on multiple medias right now. I am deaf without my hearing aids. I can talk. I grew up speaking, but without hearing aids, I'm deaf. I cannot hear what's being said. So I've got captioning up here. I sometimes have it down here. Sometimes I move it up here. It just depends on what screen it's on. Sometimes it just, just a change in comfort. Now when I'm looking up like this, I've got a big well, not big. It's about like that. Monitor that has all these different windows and gauges and stuff on it so I can see what's going on. I double check my audio output and all that kind of good stuff. That's my control board up there. So if you see me looking like this, it's control board. If you see me looking right there, that's captioning, or captioning can be there. It can be there. Just depends on where I have it. Back to trial.
or show or ask to admit the recording of the interview that you conducted, I have a few questions for you. During the time that the defendant was speaking with you, did he admit to you that he had shot and killed Caitlin Nafziger?
Yes.
Did he tell you what hand he had used to fire the gun?
Yes.
Which hand?
His right hand.
Did you ask the defendant whether Caitlin was threatening to harm either him or their daughter at the time that he shot?
Yes.
What did he say?
No.
Did the defendant explain to you whether his action in shooting Caitlin was done deliberately?
He said it was deliberate, yes.
Is it fair to say that the defendant told you that Caitlin had crossed a line?
Yes.
Did he describe where Caitlin was physically located when he shot her?
Yes.
What did he say?
She was seated on a couch.
Did he tell you where on her body he had shot Caitlin Nafziger?
Yes.
What did he say?
Her head.
Sergeant McLaughlin, did he describe to you the path of travel that the bullet took?
Yes.
If you recall, what did he say?
In one side and out the other, essentially.
Is it fair to say that he said it went straight through?
Yes.
Did the defendant tell you where his daughter Elowen was physically located when he fired the shot that killed Caitlin Nafziger?
Yes.
Where was Elowen located?
He had pulled Elowen away from Caitlin and was holding her.
So at the time that the defendant fired the shot, he was holding Elowen.
Yes, my understanding.
Did he describe how Elowen reacted to the gunshot?
He described trying to shield her from seeing anything, and that Elowen kind of put her hands over her ears and said, ouch loud, or out something loud.
Did the defendant tell you what his mindset was after he shot and killed Caitlin?
He did.
What did he say?
He said that he knew that he was screwed, and that he performed well in stressful situations, and then he talked about wanting to spend time with the kids before he wanted to turn himself in or have to be at the police station.
Very clear. Did the defendant turn himself in this instance?
He did not.
Sergeant McLaughlin, I'm showing you what is marked for identification purposes as States Exhibits 26A and B. Can you take a look at those items? Do
Yes,
you recognize them?
I do.
What are they?
They are video recordings of the interview with Mr. Duren.
Okay. And have you reviewed these specific discs, 26A and B?
I have.
And do they contain the full contents of the interview?
Yes.
Your Honor, at this time, the state would ask to strike the ID as to these items and admit them as full.
Your Honor, may we approach?
Yes.
So they're now admitting these in full. Do you know what I can do, guys? I forget. We're on a
Sidebar.
So they're admitting the copies or photos of his driver's license. I'm going to do this because I don't agree with the driver's license, even though you can go back and get it. I don't agree with the driver's license number being shown in court. I don't think that's right. They could have blocked that out. Yeah, court TV finally caught on to that one. Let me zoom.
But
they got
the attorneys at this point in time, and so at this point, we will take another mid-morning break. I think it will probably be
Court order made on their motion. They waited until today to raise this issue, despite the fact that they have had these videos with the transcript attached since Friday the 17th, which is only 10 days, actually less than 10 days after the court ruled on the redactions. They were provided with them, they have had them, they have known that today was coming. They did not raise this yesterday when no one was sitting in court. They have waited, and this is a strategic choice that they have made. At no time did the state choose which transcript to utilize. We, in fact, asked the detective to make sure it was accurate. Defense counsel complained that we corrected it. They didn't use it in their filing on September the 25th. They didn't argue it at the motions hearing on October 7th. They didn't ask the court to review it. With respect to the corrected transcript, they have had this for well over, and I'm trying to find the date, well over 6 months. This is not a surprise. There's been no effort to surprise defense. This has all been their choice. This court will advise the jury that the audio of the transcript in the interview, much as I said to the detective, the audio is the evidence. This court, I am sure, will advise this jury that the audio is the evidence and that any difference between the audio and the transcript is for them to decide. Your Honor, this is a strategic choice for the defense trying to gain an advantage. And the state objects to this entire process, but would indicate that this court has ruled on the defendant's request, has utilized the transcript the defense has requested, as has the state. And as such, the state believes this should be admitted, it should be played, and the court can give a limiting instruction.
Your Honor, we're neither accusing the state of doing this on purpose, nor is this an attempt to gain a strategic advantage. When the state opened on the quote, "You need or endangering Elwyn," and the answer yes, that drew to the defense's attention that there was an error or discrepancy in what we believed the video showed. We did not know whether the state intended to introduce the video. In all of its pleadings, it said very clearly, and in email communication with us, we're not saying we're going to introduce these statements, but if we do, then here's what we'd like to discuss. The court's order said that any issues with the transcript, I believe the court's order said should be addressed at the time that the state seeks to admit the subtitles. And so again, the timing is not any kind of strategery here, nor are we saying that there was any purpose on the state's part. I'll note that it was the exhibit was produced less than a week ago. As the court knows, it's over a 2-hour interview, a 100-page transcript, and to note differences between different versions of transcripts when there's so many in such voluminous discovery. We learned of it when we learned of it, which is after.
Your Honor, the defense was provided with 2 copies of this transcript. An original copy, which was provided, I believe, in March of 2024 or April. The video itself was provided in March. The corrected transcript, I was in error. It wasn't 6 months ago. It was 11 months ago. Defense counsel has had this. They've had experience with this. It's 2 transcripts, Your Honor. We're not talking about multiple transcripts. We're talking about 2. Of total, the state provided 4 transcripts. 2 originals, 2 corrected. One of them is not at play here. One of them does not involve this defendant.
Attorney Duren, doesn't the issue fall within the scope of the limiting instruction that you've already asked as part of the
Yes.
motion to use transcript?
Yes, Your Honor.
Okay, for purposes of the record, I'm just going to briefly indicate that the court had indicated that it would allow the state to back up a step. There are redactions to the statement which the court has ruled upon. Some redactions that were requested some redactions were made by agreement of the parties. Some redactions were requested by the defendant, and the state objected, and I issued rulings with respect to those redactions. So that's the starting place. The next step is with respect to the transcript itself. The state requested the ability to use the transcript as part of the proceeding. My ruling was that I believed that the use of the transcript would assist the jury in perceiving the evidence. Specifically, when the state asked to use the transcript as part of the trial, My ruling of October 17th indicates granted with respect to the relief requested and as to the state's proposed use set forth in paragraph 6B, which is a simultaneous playing of the video and the transcript. And to use the vernacular, it would be similar to subtitles, like pressing closed caption on most modern TV technology. That's not part of my order, that's my comment. The court deems a one-time use of the subtitles to be an acceptable aid to the jury's understanding and comprehension of the evidence being presented. Exact wording of the limiting instruction may be modified after consultation with counsel at the time that the video is played. In my perception and observation and ruling is that's what's happening right now. The proffered use of the video with simultaneous subtitles will only occur once during presentation of evidence and not during openings or closings, parentheses, to reduce any potential cumulative effect, close parentheses, and such version, meaning the version with subtitles, will not be allowed as an exhibit for the jury's consideration during deliberations. That was my pretrial ruling of 6 days ago. As part of granting the state's motion, the state had proffered a limiting instruction, which is currently on page 5 of the state's pleading dated October 14th, which at the top of the page, I will read that limiting instruction proposed by the state. Members of the jury, Exhibit X, and X is just a placeholder for what is now Exhibit 26B, am I correct? Exhibit 26B, a recording will now be played. A transcript of that recording will be visible on the screen below the video recording. The transcript is not evidence. The transcript is intended only as an aid to help you as you listen to the recording. Therefore, you may only consider what you hear and understand the contents of the recording to be. That means if you perceive a difference between the recording and the transcript, you must rely on the recording. I believe that Attorney Kettles has noted her observation of a difference in perspective as to what is said at the specific time. And as far as I'm concerned, that difference of a perception falls within the scope of the limiting instruction, and that, again, I believe the court's limiting instruction says if you perceive a difference between the recording and the transcript, you must rely upon the recording. I think that's fair commentary or cross-examination for Attorney Kettles to bring up as part of the playing of the video during a cross-examination of this particular witness, as well as any other comments, if there's any other perception as to any difference of opinion between the transcript and the perception of what is occurring on the video, that's fair commentary. I would also note that my pretrial ruling, again, was that the transcript itself would not be going into the evidence room, nor would the video which contains the subtitles, that the video with the subtitles will be played once, and that version of the video will not be going into the jury deliberation room, nor will a physical transcript. So I understand the concerns raised by the defense. I think they're well-founded concerns based upon, I haven't heard the video. So I'm making no preliminary finding of fact as to whether what Attorney Kettle says is accurate or inaccurate, but as an officer of the court whose credibility I don't question, if she says that there's a perception difference, I take her at her word for that. And so I think it's fair for her to argue that. I don't think it changes my ruling, and it doesn't change the limiting instruction, because this is exactly what I highlighted when I made my ruling on October 17th as it relates to the redactions, as it relates to the issue of the transcript. So as far as my ruling is concerned, it doesn't change my perception doesn't change my ruling as it relates to the playing of the video with the subtitles, and the limiting instruction will be granted, will be read to the jury. I think the limiting instruction is very important, and I think any perception between what is played on the video and the version of the transcript can be addressed as part of cross-examination. Attorney Kettles.
Just a couple more notes. I'll note that I don't think either party recognized this discrepancy, because I don't think the state would have opened with evidence that it knew to be incorrect. So the corrected transcript is one that I believe has been adopted by Sergeant McLaughlin. I don't believe the court or the state can allow evidence that is incorrect, that is false, to go to the jury. And so I believe that it would be appropriate to voir dire Detective McLaughlin about what he said. And if in fact he said there's, it wasn't, apologies. so it's fair to say you know you weren't endangering Elwyn, then either the jury should not be allowed to read evidence that is false, which is an incorrect subtitle, or their limiting instruction should be included, updated to say, there is an error in the subtitle. The actual correct statement is fair to say you weren't endangering Elwyn. I think we have an issue here where what the state provided as the corrected, the correct, the accurate statement is different than the evidence it seeks to admit.
I understand, and your reference to not allowing the evidence, your reference to that relates to the playing of it in real time, not opposed to anything going in the room, because I've already ruled the transcript's not going.
That's correct. It goes to the jury seeing false evidence.
Understood.
And so I would ask that we be able to voir dire Detective McLaughlin about what he believes he asked, and cross-examine him with a corrected transcript, so that if he does in fact say, it's fair to say you weren't endangering Elwyn, the jury is not getting false
Understood.
evidence.
Understood, and that they can be instructed so before the playing of the video.
Yes.
And Your Honor, I'm not sure what counsel is referring to as voir diring him, but they have adequate rights to cross-examination. The state has not done its examination of Sergeant McLaughlin, and as the court has already ruled, this transcript is not evidence. It's not going in. It's not staying with them. They're going to be told that the playing of the statement is the evidence.
Judge, it's going to be played for the jury. To say that things that don't go in are not evidence is akin to saying that testimony is not evidence. The state is now seeking to admit this evidence. It has an obligation to ensure it is not admitting evidence that is false. And so by voir dire, I simply mean question outside the presence of the jury so that the court can make an informed ruling and not allow the jury to hear false evidence.
I don't think it's false evidence I understand the concern, Attorney Kittles. I don't think it's false evidence as it relates to the playing of the video, when I'm also simultaneously instructing them that if there is a discrepancy, they are to consider the sound on the video as being primary and the transcript as being secondary. I will certainly entertain an instruction that indicates that I've been made aware, that the court has been made aware of an additional discrepancy, which will be an additional discrepancy between the transcript, between the subtitle and what you hear, and that will be addressed by counsel during their examination of the witness. And I think that's fair commentary. I think that's fair commentary that protects the defendant's rights consistent with my prior rulings. Attorney Duren, any position on what I just said?
No, Your Honor.
Again, the limiting instruction that has been proffered stresses that the audio is primary, and I'm willing to supplement the instruction with a specific reference. I think that the best way to handle it is for me to tell them that. They will realize that something that they're going to hear may be different than the subtitle, and then that can be addressed as part of cross-examination.
Maintaining our continuing objection, Your Honor, just one additional point, which is that I don't believe that the exhibit with the subtitle should be a full exhibit because it's not going back to the jury. I think it should remain as ID.
The only reason it's being offered, Your Honor, as an exhibit for evidence purposes is so that it can be played. If it's ID only, it technically cannot be played, but it certainly can be withheld from the jury's deliberations.
Correct. I mean, the perception, I want to make sure I have the right exhibit numbers. With subtitles redacted, 26A will continue to be, 26A has been identified. 26A will continue to be considered ID. 26B, 26B is the one which has been agreed as a full exhibit. Am I correct?
Yes, Judge.
And so 26B will be allowed into the jury room. 26A will not be allowed into the jury room. And again, that is only with respect to a one-time viewing by the state. one-time production, excuse me, playing by the state. If defense wants to play it further as part of cross-examination, they are certainly entitled to do so. My instruction to the state was that it would be a one-time playing. Defendant's continuing objection relative to the issue is noted with respect to the transcript and the subtitles. Again, my ruling is that the transcript and the subtitles themselves are not going into the jury deliberation room whatsoever.
Alrighty then. He ruled on that one. Okay, we're going to zoom through this. Okay, here's another motion.
Your Honor, I don't know if it's worth mentioning right now, but this is a 2-hour video. I
Oh my
don't know what
God,
the court
no.
wants to do in terms of starting it and then breaking it in the middle for lunch, or how the court wants to handle scheduling of it. I think it's 2 hours, 6 minutes and some change.
I wasn't sure, I wasn't aware of how long it was. I know it was lengthy, and I have reviewed the transcript many times, but I wasn't sure how long it was. Counsel's preference relative to the,
I
Thank
think
you, June.
to start now, go for an hour, take a break. I think that will ensure we have full attention. It can be difficult to pay full attention to our video.
okay, given the current time, I'm inclined to stop at 12:30, Attorney Duren, but I don't know where in that process, where we will be. But what we'll do is, based upon the defendant's position as just articulated by Attorney Kettles, what we'll do is we'll start the video at some point between 12:10 and 12:30. At some point in that range, Attorney Duren, whatever works for you from your presentation, we'll stop there. And I will have a full hour for lunch. Okay, so once again, I'm going to, my ruling is that the state can play the video with the subtitles. I'm going to be providing a limiting instruction as follows. Excuse me. Members of the jury, Exhibit 26B, a recording will now be played. A transcript of that recording will be visible on the screen below the video recording. The transcript is not evidence. I'm going to use the word subtitles. The subtitles are not evidence. The subtitles are intended only as an aid to help you as you listen to the recording. Therefore, you may only consider what you hear and understand the contents of the recording to be. That means if you perceive a difference between the recording and the subtitles, you must rely on the recording. Further, the court has been made aware of another potential discrepancy between the audio and the subtitles. The discrepancy will be addressed during cross-examination. Again, you are to consider the audio you hear to be the primary source of the information you are to consider. Understanding the defendant's objection to the process, any issue with that specific limiting instruction?
Just the
Continuing objection noted.
previously raised.
Okay, Attorney Duren, any issue with that?
There you go.
It's 11:23. We'll suspend right now and be back at 11:30 to resume. So a regular break from now, 11:30, excuse me, 11:23 to 11:30. We'll resume at that time. You were submitting the exhibit for admission?
Yes, Your Honor. At this time, the state would move to strike the ID off of State's Exhibits 26A and 26B and move to admit them as full.
And
And Judge, in addition to the prior discussion, I would just note that no objection to the non-subtitle version being admitted as full.
so the ID may be stricken with respect to 26B from defense perspective?
Yes, Your Honor.
Okay, the ID shall be stricken with respect to Exhibit 26B, and I'm denying the state's request with respect to 26A as it relates to the inclusion as a full exhibit, but not for purposes of presentation.
Now, Sergeant McLaughlin, before we continue with respect to this, I just wanted to ask you a couple more questions. Do you recall at what point you conducted a review of the transcript that you saw, State's Exhibit 27? At what point you conducted that review in order to determine if there were any typographical or other errors inside of the transcript?
I'd say it was over a year ago,
Okay.
close to a year ago.
And have you been able to look at your corrected version next to the version that was the original that you reviewed?
Briefly.
For lack of a better way to ask that question. I'm going to ask you to take a look at State's Exhibit 32, which I've marked for identification purposes. Now, these are bait stamped pages. Try that again, Sergeant McLaughlin. I'm going to approach and show you what I've marked for identification purposes as State's Exhibit 32 for the record, bait stamp pages 1747 through 1919. Can you take a look at State's Exhibit 32 and tell me if you recognize it? You're welcome to take it down and walk through the community.
I recognize it as a transcribed portion of the audio recording.
Okay. And if you look at that exhibit in conjunction with State's 27, which you also have, can you take a look to see if there have been any corrections made? And maybe in order to assist you, I'll direct you to a specific page. If you can look at page 89 of both of those exhibits, and that would be the 89 at the top of the page, not the bait stamp number. I believe with respect to State's 27, that would be bait stamp number 478, and I cannot tell you with respect to the other at this time.
89 on both copies.
Yes. So beginning at the bottom of page 89 and moving into page 90, I apologize.
Okay.
Are there any corrections that you made on that page? If the answer is no, that's fine.
It looks like it's the same at the bottom.
Okay, so no corrections?
Not that I'm seeing.
Perfect. Can you move to page 87 in both documents?
87 backwards.
Correct.
Okay. Okay.
I'd like to draw your attention what should be the middle of the page. Do you see any corrections to page 87 that show that there was an error in the original transcript?
In the middle of the page, I'm not seeing anything.
Okay. May I approach?
Certainly.
Going to point you to lines 12 to 17, if you can read through those sections, and let me know if there is a difference in between those lines, between lines 12 and 17 on page 87.
Okay, yes, I see it now.
Okay, is there a place in the original transcript, not the one that you reviewed, where the person who listened to the audio heard, what did the person in the audio hear? Go ahead and tell us.
So there's, in one copy, it says the word were, and in the other copy is the word weren't.
Okay, and is the word were correct or the word weren't?
The correction I made was weren't.
Okay, and you based that correction on listening to the audio, is that correct?
Yes,
Okay, you had been present, you heard the audio, and you looked at the transcript and saw that it was an error.
yes,
Okay, so the audio with respect to the statement that you took of the defendant, in that audio, does the defendant tell you that he knew that he was endangering his daughter at the time? Did you ask him that?
I did,
You asked him if he was endangering his daughter when he fired the shot, correct?
correct.
What was the defendant's response?
So I asked him if he, so I'm not reading this, correct?
Tell us from your recollection.
Okay. So I asked him if Elwin was in danger when he fired the gun.
And what was his answer?
So I asked, I actually, I have to read this, I think, because I asked, it's fair to say you weren't endangering Elwin, and he said yes.
Okay.
So it's fair to say that he wasn't endangering Elwin.
Okay, but the transcript that is the original transcript to this audio, the word weren't came across as the word were, is that correct?
Correct.
Okay, but in all cases, just like you did, anyone listening to the audio should take the audio as the evidence, is that fair to say?
Yes.
Your Honor, at this time, the state would, pursuant with all the orders of this court and the court's indication, publish State's Exhibit 26A for the jury.
Okay. Members of the jury, Exhibit 26A, a recording will now be played. Subtitles for that recording will be visible on the screen below the video recording. The subtitles are not evidence. The subtitles are intended to hear.
We've already heard that
So
all.
about the right to stop, there's two questions. And I kind of like add a little bit to that on my own. Like, if you decide to start talking to us and answering questions, and I ask you a question that you don't want to answer, so you kind of want to continue talking to us, just say, I don't want to answer that question. Fair enough. And then we can move on. Do you understand ancient threats? Right, yes, next to this. And that's what you're showing second. And understanding these rights, are you willing to answer a question? Yes. Remember, yes, next to that. So, yes. And that initial that. So just initial, sign in. It's, So your girls are at Cheshire Medical, which is down there in Keene, affiliated with government. And my understanding is that Caitlin's aunt, Brenda, is assuming DC, so these who have in New Hampshire, you're from Minnesota originally, right? Originally, yes. In New Hampshire, DC have the Department of Children, Youth, and Families. So they're kind of like CBS, whatever it is in Minnesota, the Child Protection Services. So that at this point, they kind of like review everything. They actually have some questions that I want to ask you too. Just want to tell them and stuff like that. They kind of step in because of what's going on. And then they always try to get the girls to Sumner, whether it's family in Minnesota or family here in Hampshire. Right, this is probably the closest that we can assume. So she's kind of been contacted or in contact with us. So that's kind of like plan A at this point, assuming PCOF is okay with everything. It sounds like Brenda will be kind of agree with the situation. Is that a good option for now?
For now, I guess how this goes, can I just ask questions whenever? Does that matter?
And as we go. Yeah. Well, I'm very easy, as you probably figured out.
Yeah. Well, I was gonna ask, I guess did someone contact the police?
Third.
About what happened?
Oh, yeah. Yeah.
Say who?
Well, yeah. So what happened was at like 4 a.m. this morning, I went to Amarillo on a statewide overnight. It will be up at 4 a.m. And that's something we started to do.
No, I meant,
Berlin.
how did police know anything even happened?
They don't know. The Berlin police went to the house department, and that's from there. I don't know how they got home from their neighbors. But
I mean, I was asking for a reason, but.
yeah,
I guess I'll say, for just family, kind of one of the things was I want to make sure that my mom was aware. And that was my preference. So I just wanted to make sure that my mom knew that the kids were here.
where's your mom?
She's nice.
It's 2024. I couldn't tell you if I were off the top of my head. You know what I'm saying? Is it your phone?
It's in my phone, yeah.
Where is your phone? TV.
Probably at the scene.
What's your mom's name? E-O-R-E.
D-V-R-A.
Same last name? So, do the kids have a primary care in New Hampshire? Yeah.
No, I literally, I was supposed to have a phone call today.
What hospital? Or where?
Because,
I don't know what's going on with YouTube and the name change thing and all that kind of glitchy stuff. I have no clue. All I know is that fan that I feel a tick, 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 tick. It's driving me back crazy.
well, we'll probably get into this, because I'm assuming you're going to want like an entire walkthrough. We lived in Nevada before here.
Minnesota, Nevada, and New Hampshire.
So Minnesota, Minnesota was never really the picture. I've been in Nevada, I mean, it's like a picture, I guess. We've been in Nevada for the past, well, she was in Nevada, and all of us were in Nevada for the past 4 or 5 years. But I lived there before that.
Okay.
And then, I guess we can get into more details, but anyways,
So because of what happened, because of the way the girls came to the hospital, there's a lot of questions. I think the highlight questions are, do they have any injuries that you're aware of? Any poisoning or access or anything like that? Are they totally healthy as far as you know? How about like the allergies? Anything else like that to do with that? They would be concerned about? Totally healthy. What did they order at the restaurant? Did you get it?
Oh, they were, okay, I can't remember. Was it you that came to the door? Okay. Well, no. Everybody said. Oh, no. I had, well, I guess.
I'm sure they've eaten by now. And I offer you food, but.
Yeah, and they ate, yeah, I mean, they had been eating, this was more so.
July.
I could probably go into more detail on it, but, because I was actually already in New York, but I turned around because I didn't want to, I ended up deciding that I wanted to, like, I'll keep this surrender here in Hampshire. And then, yeah, then I thought I'll try to eat breakfast. I was actually pretty hungry.
So,
Somehow, and I didn't notice when I tried to eat, I was like, because I saw the Chili's, and then I saw the police department right there, and I was like, oh, yeah, if I go to Chili's, then like, he's sitting right there. My hope was that what I wanted to do, which I will say, everything was very professional. So, I'm very appreciative of that. Because I just didn't want to get caught like what happened, because I didn't want anything crazy to happen to the kids there. Like,
oh, wait a second.
I wanted to kind of walk in and be like, hey, here's the kids, like, here's the kids.
But it worked out okay, isn't it?
I guess, I mean, obviously my biggest thing is that I didn't actually, like, well, maybe the personality, but, you know, like, I have to, okay, I'm over, so, yeah, you know, so, let's just,
So you know a lot more about what's going on in the last day or two than I do. I'm saying that because I'm probably going to ask a lot of stupid questions that you would assume I will already know. But that's not. I'm just turning this back around because the cancellation of the Amber were actually just turned last night. Just back on that. Yeah, so that's kind of like that. That's what I woke up to at 4 in the morning. So I found with you, so I think. This is something that, in this case, actually, is very useful. Really safe, right? So I apologize for that. But this is a good control. So we started to kind of talk a little bit, and I was saying that I'm going to ask you some questions that you probably should know this already, or no questions. My day kind of changed a little bit after what happens. But I was going to ask, both Elowen and Valen are your daughters, but also Caitlin's daughter. Caitlin's daughter. So that was one question. When did you move to New Hampshire?
so I got here, 25. And specifically, it's just because that's what was for the budget. When I was working, I got, basically, I got hooked up with the place. And that's just what went around.
Yeah, you can dance to it. You just got to double time it.
I don't know if you're gonna want to hold me up. I don't know.
Whatever works for you. Whatever works for you.
Because,
Well, I was starting to move into insurance. So, a couple of years ago, she had been talking about how she didn't want to be with that. And I actually grew up at the end of but I said, I said, saying, okay, and where do we it's beyond what place, well, I mean, what place we can go here, and she got here in Hampshire, so that was what she talked about, and just for, and yeah, so this got brought up, and it started catching my attention. And then, like, as we were kind of several different states, where I go to, and I kind of make it, and actually, from there on, it's a little bit of tangent, if you want, I'm sure it's yeah. So then we had agreed, okay, New Hampshire. And then, so we're then fully prepared. This was, so our lease was up in Nevada on
Man, it's gonna put me to sleep, y'all.
our August of just this past year, 23. And
It will.
so the lease was
It's
up.
gonna put me to sleep.
And then when we started getting pods shipped to get over stuff right into Hampshire, then she decided, without telling me, that she ordered her own pods and then got our stuff and shipped them to so I guess because I guess I should say, I should be clear on this, that prior to that happening, of her ordering her own files, she took pretty much 90% of her stuff.
That's 60 feet.
So prior to that happening, like, we had problems, but that was like legitimately the first time I yelled.
Thank you, Night 5. We love Night 5. Thank you. We love Mr. Nightbot. Thank you. And that I gotta take a mental break from that. It feels like 60 beats. Oh, I'm about ready to just turn the volume off and let's read the captioning. Oh, y'all, I'm getting a headache again.
So, like, even if we had issues, it was, I'm very big on, I've always been very strong on their family, raising kids. So with all the problems, I was trying to just say, okay, like, it doesn't matter. I just suck up my pride and it's for the kids. So this is not anything. But anyways. So anyways, that happened to where, so all of our stuff went to Minnesota, and I obviously, the plan was to go to New Hampshire, and that was without her saying anything. The moment I knew was when the pods, like, were actually there, and that was when I confirmed about this, and then, shortly after, she took our 1-year-old, without me knowing. She didn't say anything. She took the stroller, and she was going to the park, as everybody, which was
took the stroller,
It
and just left.
had
She walked in the park. I didn't think too much of it. But then it was like several hours later, and they hadn't returned, and so I got to the park, and they weren't there. And then I was trying to call, and be like, what is going on? And she was at the airport, taking her home and bringing her to Minnesota. And I ended up like driving to the airport, trying to be like, yo, what is going on? And I called like my parents, I called her parents. And this will be common in conversations, but I've always tried to stay very, I've tried to keep everyone informed, so like my family and her family. So when that happened, I talked to my parents, I talked to her parents, and like, what is going on? I regret not just staying in Nevada. I know that was my first mistake, because if I just stayed in Nevada and hadn't talking to my family lawyers, I kind of lost power because I followed her to Minnesota. I ended up talking to her family and my family, and everyone kind of convinced me that, you know, I'd like keep the kids together, because I still had Ellen. Basically, like, you just keep the kids together. Just come back to Minnesota, we're all here, and then we can figure stuff out, and then you just move on to just come back here, I guess I just, as a clarification of how, like, I had no idea that she left the program at the time. All of her stuff was still, I kept all the picture of it. All of her stuff was still everywhere, all the times. So she didn't even take anything, she didn't move anything, she just put it in. So anyways, I followed to Minnesota. I tried to make things work. There was a lot of fighting. She was very aggressive about, she's the mom, and she has all the rights. And so it was getting to a point to where she was deciding to keep the kids away from me. And there's a bunch of different stuff that I've been telling them to about it, where again, I'm so worried. But they're kind of explaining, like, the UCC, JE, the gathering thing, from custody and so on. So where they're kids. However, I guess that's what I'm saying. She didn't have kids. And I'll let me see that. I finally had kind of a sit down with her and her dad. And I kind of gave a shot of, hey, I can throw everything out. Can we just continue the post-engagement? And she agreed. And this was in, I don't know the exact date, probably finish. It's probably around 2 years, but all the texts and phone calls and stuff like that, I'm sure that we didn't go through this. It's kind of verified. Or I didn't announce that you specifically when we met, or something, texts that day. But it was October something. Well, part of that was
It's the-
reading that, well, okay,
why don't we just read the captioning?
they're in Minnesota.
Yeah. But I was thinking just specifically what when we not, there definitely text that day, but it October, okay? They're in Minnesota. There's no there's holidays coming up. Obviously there's Thanksgiving, Elwin's birthday is in December 2nd. Then there's Christmas and New Year's birthdays, January, New Year, then Valen's birthday, January 15th.
And there's holidays coming up, obviously, it's Thanksgiving, his birthday is December 2nd. There's Christmas, and then his January 2nd. So, we agreed, okay, stay here then until his birthday. And then we'll continue on to New Hampshire. So we were on, and things were okay, not that we were necessarily like having conversations, we were still in two separate places. But twice a week, I just drive. I guess that's all the friends I know, but I was in the northern area of Minnesota, and she was in Minnesota. But twice a week, I was fine with driving down, like, dropping off the kids, or just driving back and forth. So we had a setup that is, and then once the time came, I drove out here, so that was the thing that I wanted to just really do was, and I was gonna drive out with Ellen, which I guess I was there, I drove from the back, so it was a bit of a, and she was fantastic, but I was not very good.
Well, I think we have 2 hours to do. Okay, we got break and then we got 2 hours. Him through.
Thank you. Please be seated.
Oh, yes. I will do.
And I couldn't do that. And I was, there was a few times, like I was sending, I don't remember the exact amounts, but I'm sure they can be looked up, but I would send like $100 one month or like $200 another month. And, anyways, so I guess, yeah, I forgot because I went on a tangent. I do that a lot. But because yours, well, because what were we talking about? The New Hampshire?
Yep, you would move to New Hampshire on January 23rd. She began asking for 2,000 a month, and then threatening to take.
But that was, when she asked for 2,000 a month, that was August or September, when we first got to Minnesota.
And then you paid whatever you could.
Yes. But yeah, up to New Hampshire, up to now. Once I got to New Hampshire, then she got very aggressive about how she was going to keep Valen in Minnesota unless I started paying her money. And she got into a whole thing, and it got really bad when we had a phone call to where she was yelling that she was going to have me arrested, and she was just straight up lying about it. I don't know. Yeah, I read on that, but because I would like to remember exactly what our phone call was before we started guessing. But anyways, she was basically threatening to like put me in prison and take the kids away and all this stuff, and I did not bite. I just was saying I'm not gonna play these games. And the conversation just ended. And I was reaching out to her family. I was talking to her, I guess a little bit more details. Her dad is her adopted dad, and he's in a different relationship, and then her mom is in a different relationship. but I kept in touch with both of them. And this is something I did the entire time. So these past like year, really, I've been in contact with both of them, both families, trying to talk everything out, because my conversations with Caitlin would never go anywhere, and so I was trying to get her family to help out. But anyway, so I talked to both of their families and saying kind of what was going on. By that time, Caitlin had stopped talking to her mom altogether and told me not to talk to her mom. However, I did reach out to her mom after she like threatened to arrest me, so take me as a way. But I'd also been talking to her dad about it. But she doesn't tell anyone anything. So even when her dad tried to, he went to her where she was staying, the house that she was staying. And I was basically just trying to be like, trying to ask him, hey, can you check on Valen? Because I wasn't seeing Valen. So basically like, hey, is Valen okay? And he went over there, and apparently Valen was just sleeping, and then he didn't ask to see Valen. And then he just didn't push it either, because she wouldn't tell him anything. And he didn't push the subject. So he, and this is a text, but he just basically texted back to me saying, like, yeah, she just doesn't tell me anything. So he's like, so he just texted me, hey, I went over there, Valen was asleep, so we didn't see her. And then I was basically saying, oh, so she just, like, she didn't say anything, like nothing was happening. Like she did just have this explosive argument. And he just said, no. And I'm not gonna, obviously, and the text will show what exactly his words were, but he basically just said, she doesn't tell me anything. But after I had reached back out to my Minnesota lawyer, because I was really afraid that something would start, that she would try to lie about something. I guess I'll say in general. Well, again, I don't remember, like, don't quote me specifically on this, but where it would, the big thing that she was lying about on our phone call was that I had taken Ellen to New Hampshire without her permission, which is not true whatsoever. We didn't actually sign anything, which I actually did have a conversation with her about it, and I talked to some other people, because obviously that would help. But I also felt like so many people knew the situation. It was like there were so many people that we had been talking to, and again, her dad was at this meeting that we had in October where we were kind of talking about this, like she hadn't agreed to it and everything. So I felt like that, even without any sort of written thing, that just wouldn't hold up in court. But anyways, so and now I forgot where I was originally at with that. With her.
It was just the dad check on Valen. You got to think, I'm not sure when Caitlin moves to New Hampshire or comes to New Hampshire, but
Yeah. I was talking about to where I was reaching out to this same Minnesota attorney that I've been talking to previously. I reached out to her again and was saying, hey, I think like she's gonna try and pull something. Like, and this is where I was going, because I was afraid that she was gonna lie to police or whoever, and I was gonna have some I would hope that no one would do, because you would do like some sort of due diligence instead of just like randomly taking someone's word and then coming to a house. But I did actually call the Berlin Police Department too, because my lawyers, I was asking again my lawyer, like, hey, should I like give the police a heads up and be like, yo, there's a civil thing going on and she's trying to make some stuff up. So I did actually call the Berlin Police Department. And
I'm just curious. It's not totally relevant, but I'm just curious. So you come here on January 23rd. When did you call Berlin Police? Do you remember the month?
I don't, again,
I don't want to assume, but it sounds like it's after several months of making subpoenas. Is that accurate?
no, I mean, we've only been here for
Just
a
January?
month. Yeah.
Usually you don't remember what you called, just to give them a hand.
Like 2 weeks ago, I don't know. Because all this stuff, like again, with the Berlin Police Department, like that, obviously the call logs, it's gonna have that. And I don't even know if you could get the actual voice calls.
No.
Okay, yeah. But you can at least see the call log that I did call the Berlin Police Department, whatever it was.
And all the text messages.
Yes. But anyways, but they said anyways, like, hey, we would get involved anyways. But anyways, whatever. But I talked to the lawyer, the big issue though was that I just didn't have money. And so the lawyer wanted a retainer, obviously, $4,000. And I was trying to figure out how to get $4,000. Because my thought was, okay, like this is gonna go to court, because if she's gonna refuse to bring her daily here, like this is, or like whatever, and continually just make up these lies, like, I don't know, if she never gave me permission to take it home here. I was like, well, there's no shot, like I have to figure out how to get this retainer. But then, because the move, I got a credit card to help with the move, and so my credit was dipping. And I tried to go to like the credit union right in Berlin, and I did apply there to try and get $4,000, and they actually denied me, and it was mainly just because of my income, because I couldn't show any income outside of the previous move. But they denied me, and I was like, really, I didn't want to sell my car. I do. My car's paid off, but I did not want to sell my car, so I was really trying to figure out like how to pay for some of this stuff without selling my car. But after having conversations with like getting back to her dad saying, oh, like she didn't say anything, and like apparently everything's just fine. Then I texted her. So again, this is a text. So I was like, I guess part of her argument to where, again, to what this big one, to where she was like, threatening to arrest me, whatever, to where she was asking for more money, but part of that too was that she wanted to put both the kids on her taxes. And all I said, that sucks that you can't get the voice calls.
Guys, I'm going to give you a choice. Do y'all want to zoom through this and go on to the next part of the witnesses? I don't know if I can handle another hour of the ticking and another hour of mumbling that nobody can hear. It's up to you. I'm going to give y'all a minute to answer because it's driving me crazy. Oh my God, yes, please. All right, you got it. We're getting ready to go into day 4.
The phrase hunter, fisherman was omitted. Line 9.
Jury, that's number one. Number two, the version of the video that has been admitted as a full exhibit, that version does not have subtitles on it, and that version has been admitted as a full exhibit, so that version will be going to the jury. I've already instructed them that they are to consider the audio to be the primary evidence, and they are to rely upon that, and the jury is presumed to follow my instructions. So that is my ruling with respect to that. Satisfied with the record, counsel?
Yes, Your Honor.
Okay, jury. Thank you.
That would be fair. I would hate to differ on that. No. No, thank you. That would be freaking insane. All right, we're going to start off with day 4. Yay! Day 4.
Rise for the honorable jury.
But it's not as black. Very, very little. It almost feels like it's on my ears.
Fourth County Superior Court is now in session. The Honorable Jonathan S. Brazel presiding.
Thank you. Please be seated. Detective Sergeant, you're still under oath, sir?
Yes.
Thank you.
Why did we lose Mike? Why did we lose Mike? I hate this new YouTube's doing some new stuff in here. This the same dude as yesterday? I think so.
Ask you every morning, because there is a media presence with respect to this jury, please.
Same guy.
I would ask you now to raise your hand if you have had any exposure, even if it was inadvertent, relative to any of the media coverage with respect to this matter. Let the record reflect that none of the jurors have raised their hands. Thank you again for your adherence to my instructions. Thank you. And Attorney Kettle's ready to proceed?
Yes, Your Honor.
Detective Sergeant, you're still under oath, sir.
Yes, sir.
Thank you.
Detective Sergeant, I'm going to back us up a little bit and just go through in some bite-sized chunks, okay?
Okay.
So we were talking about the incident itself, what Dustin told you about the incident.
Oh my gosh, get on the mic.
It happened super fast.
Yes.
He said, I mean, there was, again, it was like training to where it was, he said, I mean, there was, again, it was like training.
Yes.
He said, to where it was just grabbed it, cocked, grabbed Elwyn, and then right when I shot, it was just immediately, I grabbed Elwyn and like ran out of the house.
To the car.
Yes, I'm doing it bite-sized chunks here. Yes.
Okay. Yes.
And just immediately ran out of the house and put her in the car.
Yes.
He said, after he put her in the car, he sat for a minute talking to Elwyn.
Yes.
He was making sure that nothing had happened to her.
Correct.
He was checking to make sure she didn't have injuries.
Yes.
She didn't.
Correct.
He loaded the car up.
Yes.
He got the kids in the car.
Yes.
He was thinking, at some point, I'm going to turn myself in.
Yes.
But first, he was going to spend some time with his kids.
Mm-hmm. Correct.
He said he drove to Concord.
Yes.
Once he got to Concord, he sat with Elwyn and Valen again.
Yes.
And at that point, they were both good and they were happy.
Yes.
He called his mom and told her what had happened.
Yes.
And he told her to call the cops.
Probably should call the cops is my recollection, but something to that effect, yes.
told his mom he was going to turn himself in.
I believe so, yes.
He told her he wanted some time with the kids beforehand.
Yes,
He told you that after he talked to his mom, he turned his phone off.
correct. Went dark, I believe is what he said.
He said went dark, and he said, I turned my phone off.
Yes.
He said he drove to somewhere in New York State.
He believed it was New York State. Yes,
He and the kids got a few hours sleep.
correct.
He woke up and initially thought, well, I'll just surrender at a random police department.
Yes,
But then he decided he should probably do it in New Hampshire.
correct.
And by do it, he was referring to surrendering or turning himself in.
Yes,
So then he started heading back.
yes.
He decided to go to Concord and then just surrender there.
That was his plan, yes.
But he wanted to just sit down with the girls and just have breakfast somewhere.
Yes.
Just a couple more questions on what Dustin said in relation to his training. Dustin said everything was so fast. It really was like training. It was instant.
Referring to his marksmanship training, yes.
He said it was like muscle memory.
He did say that.
He said it was his training coming out.
He did say that, yes.
One moment. No further questions.
Sergeant McLaughlin, just two questions. How many police stations or police barracks are in Keene?
So there's a state police barracks in Keene, so that's one. The Keene Police Department is two, and the Cheshire County Sheriff's Department is in Keene as well, so that's three.
And to the location where he was originally stopped by, or initially stopped by police, he passed right by your barracks, is that correct?
He even commented that he saw the sign for the state police barracks.
And he avoided that.
Yes,
Now, how many police stations between Keene and Concord?
a lot. You don't expect me to know how many, do you?
No, that
Okay,
many, right?
a lot.
You can't even judge.
And even from the Vermont border into New Hampshire, there's at least Chesterfield Police Department.
Okay. Did the defendant talk to you about whether he had a connection to Concord, New Hampshire?
No,
Now, everything in the defendant's statement, all of the words that he provided to you, that's what he told you, correct?
that's correct.
Anybody else tell you those words?
No.
No other questions?
Recross?
No, Your Honor.
Okay, thank you. Can Detective Sergeant McLaughlin be excused?
Yes, Your Honor.
Okay, thank you.
Thank you, Ron.
Senator, may I approach the monitor?
Sure.
Interesting. Who's next? Come on. How? Oh, oh.
Your Honor, at this time, the state has no further witnesses and we would rest.
Okay. All right, thank you.
Hey, rest.
Okay, members of the jury, at this time, I know that we just started for the day, but we are going to be taking a break at this point. So I'm going to request again that you retire to the deliberation room. Please do not discuss any aspect of the case. Do not discuss with any other member of the jury. If anybody does that, please report that.
He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she didn't. He loaded the
Okay, they're
car
gonna,
up, got the kids in the car.
this is typical. They're gonna ask for it to be dismissed.
He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlin used force against Elwyn when she restrained Elwyn in her arms while committing a burglary. She entered or remained unlawfully in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping or 633-4 interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state.
Oh, sorry. My bad.
Attorney Spicer used the word state.
You in fact have his actions, I think, further, beyond what he told the police when he had an opportunity to tell them why he did what he did.
There we go. My bad.
Dustin said he grabbed the gun, chambered it, and while grabbing Ellen, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Ellen. Dustin said everything was so fast, it really was like finger snapping training. It was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Elwyn, ran out of the house, put her in the car. He sat for a minute talking to Elwyn. He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she didn't. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlin used force against Elwyn when she restrained Elwyn in her arms while committing a burglary. She entered or remained unlawfully in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping or 633-4 interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take
from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlin was threatening to do so. She was attempting to do so. She was refusing to leave the home or release Elowen. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Elowen to Minnesota or to New Hampshire. Harassment with the purpose to annoy or alarm another, communicates any matter containing.
Okay, guys, I need to give you an update. Remember, we've been waiting for the PET scan results from my friend and sister-in-law, Jennifer. The cancer is only in the chest where they've seen it in the hospital, and then the lymph nodes in the chest, no cancer anywhere else. So they're going to do chemo and radiation. They think they can get it. Good news, because I can't lose another sister. I can't handle another one loss. My sister Tracy passed away November 30th a year ago. So I don't want, I just so was not wanting to walk down that road again. Now, cancer, no one's, it's still not fun. It's still a slippery slope, and not saying that, but prognosis is far better than what I thought. So I'm happy. They're going to start her chemo next week. Now we get to walk through chemo, but I'll gladly walk through chemo with her. All right, back.
Any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person's actually placed in such fear. And the course of conduct would be restraining and yanking back Elowen. Theft by extortion. A person is guilty of theft.
Yes, got a fighting chance.
He obtains or exercises control of the property of another by extortion, and with a purpose to deprive him thereof. As used in section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened, or to any other person, or to property at any time. Or B, subject the person threatened or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining Elowen. Theft by deception. A person commits theft if he obtains or exercises control over the property of another by deception with a purpose to deprive him thereof. Deception occurs when a person purposely creates or reinforces an impression which is false, in which that person does not believe to be true. Attempting to obtain Dustin's money, deception would be telling Berlin PD that he took Ellen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him. Evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlin was using unlawful force against Elowen when she was restraining her in her arms, squeezing her while attempting to commit interference with custody in Dustin's home. So she was in his home, she was attempting to commit a felony level offense and using unlawful force. If the court disagrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect to either of those charges. Reckless conduct alleges that Mr. Duren recklessly engaged in conduct which placed another Elowen in danger of serious bodily injury by shooting Caitlin while holding Elowen. Two reasons the court must dismiss for insufficient evidence. One, The facts don't show beyond a reasonable doubt that Dustin was holding Elwin while shooting Caitlin. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Elwin. He grabbed the gun, chambered it, grabbed Elwin, pulled her back out of the way, and shot. The state alleges that this action was reckless, even though we have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting. He knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Elwin, that he pointed the gun at Elwin. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Elwin out of the way. He made sure that she was not at risk. He aimed the firearm away from her. We heard that the gun he used has many safety features and cannot accidentally discharge. In terms of the risk to Elwin, this is no different than if Dustin and a child were at a firing range and Dustin fired, not towards the child, but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired is not, without evidence that the gun was aimed at or near her, rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor, the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Ray NK, 169 New Hampshire 546 defines what endangering the welfare of a child means. A person is guilty of endangering the welfare of a child when he knowingly endangers the welfare of a child under 18 years of age by purposely violating a duty of care, protection, or support he owes to such child. So the state's required to prove two things: that Dustin knowingly endangered the welfare of Elwin, and two, that he did so purposely by violating a duty of care owed to her. And so again, the evidence here is that Dustin grabbed Elwin from Caitlin and moved her out of the way while simultaneously firing one bullet in Caitlin's head. He said, right when I shot, it was just immediately I grabbed Elwin. He did not violate a duty of care. He acted out his duty to care, to save her from harm, to remove her from the situation. There is no evidence Elwin was endangered. Evidence is sufficient to prove endangerment if it establishes, and again, this is from In Re NK, if it establishes that the offender engaged in behavior creating an actual and significant risk of injury to a child's welfare. The state didn't offer evidence of welfare beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Elwin appeared well-kept and well-nourished. That's what Dr. Robertson said. There was no evidence of the volume produced from the gunshot. We heard evidence of the amount of pressure it takes to pull a trigger, but no one testified how loud the gun was. And the state did not present evidence of how loud a Beretta 9mm pistol is when it's fired. And that's no different, Your Honor, I would argue, that when you take a child to a musical festival with loud music without ear protection. And also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, I can see where this is going of like, could it be that I'm endangering Elwin by what I did? And I would very much say no. And then Sergeant McLaughlin responded, yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you were not endangering Elwin. And Dustin responds, yes, mental states of both knowingly endangering the welfare of a child and purposely violating a duty of care. Thank you.
Okay, Attorney Spicer?
Thank you, Your Honor. They asked that the court deny the motion. In the light most favorable to the state, there has been sufficient evidence provided for a rational trier of fact to find each element of the offenses charged. I'll note for the court, as this court is aware, it's the defendant's burden at this stage of the proceedings. I don't believe that they have met that burden shown that any of the charges should be dismissed. I will start with the murder charges. The defense argued that there has been evidence presented of self-defense through the defendant's statement. I would not agree with that. At this point, I'll make arguments, assuming that to be true, but I would state for the record, I don't believe that that's true. The defendant's statement established that he told Sergeant McLaughlin that he killed Caitlin Nafziger very deliberately, that he did so because she refused to leave his apartment, that he did so after a day of arguments about things that they had been arguing by his own testimony for months and weeks. None of the statements that he claims that Caitlin made the day of the murder, that she was going to take the kids away from him, she was going to call the police, are things that were new to him. By his own testimony, she had said similar or identical things to him before in other contexts, and at no point did he shoot her in the head. His testimony, I think, was pretty clear, certainly in the light most favorable to the state, that he killed her because she wouldn't leave. He wanted to put her and the kids in the car so that he could drive them to her Aunt Brenda's house. He was in the process of doing that by his own statement. He put Valen in the car seat and got her ready to go. He was trying to take Ella in so that he could do the same thing, so that he could get her into the car and get Caitlin moving. Caitlin refused to let Ella go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her. And so, just for purposes of the record, I don't think this is disputed. With regard to second-degree murder, both the knowing and the reckless varieties, there has been sufficient evidence presented as to each element of those offenses. That the defendant caused Ms. Nafziger's death, and that he did so knowingly, and in the alternative, recklessly, with extreme indifference to the value of human life. The defendant has admitted that he pointed his gun at Caitlin's head and fired it. He has admitted that he knew the bullet went straight through. He has admitted, in essence, that he was aware that his conduct would cause Caitlin's death by pointing a gun at her head and pulling the trigger, particularly in light of his statements about his own expertise and his own experience with marksmanship and handling of weapons. So I don't think there's any argument there. I didn't hear anything from the defense about this. I'd ask that you find that the state has satisfied the elements of knowing and reckless second-degree murder. Again, keeping in mind that there has to be some evidence of self-defense before self-defense shifts and the burden moves to the state. Understanding that the state does not admit that that has happened here based on the evidence before us. Even if that is the case, there is sufficient evidence at this stage in the light most favorable to the state where the rational trier of fact could find for the state. The case law on this is somewhat convoluted, so I don't want to misstate the standard, but I'm citing State versus Pennock here, 168 New Hampshire 294 at 307. It's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences therefrom in the light most favorable to the state, could have found beyond a reasonable doubt that the defendant did not act in self-defense. And that is an awkward formulation. But I would submit that there is certainly sufficient evidence before the jury for a rational trier of fact to find in the state's favor on that issue that the defendant did not act in self-defense beyond a reasonable doubt. I'll talk now. I'll refer now to the facts. The defendant must actually and reasonably believe that he is acting in self-defense for any of the various forms of self-defense to come into play. He must actually believe it, and that belief must be reasonable. The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlin. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, my plan all along was to turn myself in. He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, I acted in self-defense. At no point did he tell Sergeant McLaughlin, I did what I had to do. I didn't want to kill Caitlin, but I had to do it. Words to that effect. At no point did he say the word kidnapping. At no point did he say anything indicating he thought Caitlin was kidnapping the children. This kidnapping is a fabrication that the defense has presented here. The defendant himself did not believe it, and that's what the evidence shows, certainly in the light most favorable to the state. There is no evidence that the defendant believed it was necessary to use deadly force to defend himself or another. The defendant told Sergeant McLaughlin, when asked, that Caitlin did not threaten him, did not threaten Ellen physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense, or acted in self-defense, or acted because he thought Caitlin was going to steal his kids, or acted because he thought he was never going to see them again, or that it was necessary to prevent these things. The defendant called his mother and told his mother, in effect, I shot Caitlin, you should probably call the police. He didn't tell his mother, I had to do it. He didn't tell his mother she was going to kidnap the kids. He said, I shot Caitlin, or words to that effect, you should probably call the cops. In the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner. I'll go through the various forms of kidnapping. I'll put this on the record, Your Honor. Under State versus Monroe, and I don't have the site handy. Here it is. 173 New Hampshire 469. The defendant not only must provide an actual notice of defense in support of the defenses they intend to pursue, but there also has to be specific presentation of, or sufficient notice of the factual allegations supporting the defenses. With regard to burglary and all those other flavors of kidnapping beyond, flavors of self-defense beyond kidnapping, I don't believe that was done. Walking through each of the varieties of kidnapping in 627-4, starting first with 2A, I addressed that. There is no evidence that the defendant acted because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B, the defense presented this court with a variety of crimes they claimed that Caitlin could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duren's home. I can only imagine what the defense attorney would say if the state tried to charge someone in Caitlin's position with burglary, based on the statements and the facts and the circumstances in this case. I'm not going to address each of those crimes. I don't think it's necessary. I don't think the facts support them, and certainly not in the light most favorable to the state at this stage. There is sufficient evidence to show that the defendant did not actually believe Caitlin was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlin was going to had a purpose to commit theft by deception or false imprisonment or anything along those lines. So at this stage, in the light most favorable to the state, there is not sufficient evidence here, or there's not a lack of evidence that would allow this court, on the state of the evidence as it is, to dismiss the murder charge because of the defense arguments. 2D, 627-4-2D, defense counsel misstated the law. Defense counsel stated that under 627-4 2D, well, I'll state, the law says that a person is justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor while inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlin was likely to use unlawful force in the commission of a felony against him. Defense counsel clearly claimed that he was going to use force against, that Caitlin was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that. And there's certainly not sufficient evidence that the state cannot defeat it, and that there's that no juror could find for the state on this issue. With regard to kidnapping, I'm going to ask the court to reference the arguments that we made in our pleading filed yesterday about the law. I can summarize them here. I don't want to get too far into the weeds, but to come back to the actual unreasonable belief, the court knows what the defendant said in that statement that was put into evidence. That is the evidence of what the defendant, at this point, actually believed happened inside that apartment. I'll note also that at this stage, credibility determinations with regard to witness testimony must weigh in favor of the state when they're equal. And the court can assess the credibility of the defendant's statements or different parts of the defendant's statements, taking into account that he is providing his account of what happened, his story of what he told the police about what happened. With regard to kidnapping, as we stated in our pleading, Ms. Nafziger legally could not kidnap her own child under 633(1)A. Could not do it. Based on the interplay of 633(1)A and 633(1) and 627(4)(2)C, as we say in our motion, interference with custody is not a basis for the use of deadly force. That is what the defense is arguing. The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlin could do. And to find that would be to add interference with custody to the list, to the narrow circumscribed list of circumstances where the law allows the use of deadly force. And that should not be the case. And with regard to each of the different versions of kidnapping, at this stage, again, the defendant did not tell the police that he killed Caitlin because she was holding Ellen hostage. There was a reference to his training. The sergeant asked the defendant about if he had any sort of hostage training, and the defendant, it was somewhat difficult to see what he said or understand if he was giving an affirmative answer. He may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly, that's what I thought this was. This was a hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal. The defendant actually and reasonably believed there was a hostage situation and that is why he killed Caitlin. And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlin was committing a kidnapping in ignorance of the law, which says that what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are, he is mistaken on what a kidnapping is in the state of New Hampshire, that is not an excuse. The defense argument is built upon the idea that ignorance of the law is an excuse, and this court should not agree with that. 633(1)(1)A is the ransom hostage situation. I'm not going to address that any further. 633(1)B says that there's a kidnapping if someone confines a person to avoid apprehension by law enforcement. There's no evidence that that's what was happening here, and defense has not claimed that. 1C, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlin was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay. And 633(1)(1)D
I'm shaking.
require that the victim confined, or Caitlin confined Elowen for the purpose of committing offense against Elowen. That is not, there's no evidence that Caitlin was intending to hurt Elowen. And in fact, the defendant disproved that. He said, yeah, she was not threatening to harm Elowen. As Sergeant McLaughlin testified, the defendant told him Elowen was yelling, but
Shame.
the defendant said it was a combination of things. It was not just because Ms. Napster was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond reasonable doubt on the knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or the state of the evidence at this point does not justify dismissing them on a self-defense ground because there is sufficient evidence for the jury or the rational trier of fact to find in the state's favor on the self-defense issue. Moving to reckless conduct under 631.3, the elements of that are the defendant engaged in conduct that either placed or may have placed another person in danger of a serious bodily injury, and that he did so recklessly with a deadly weapon as a firearm. In this case, the defendant, by his own admission, grabbed Elowen and then fired a gun at Elowen's mother while holding her so close that she complained instantly that her ears hurt.
Look, I got the shakes.
Injury does not require evidence of actual trauma or actual diagnosis of injury. In this case, we do in fact have the testimony of a doctor. She sustained an injury to her ear. That was what the doctor said. The defendant used a deadly weapon.
I'm nobody important. Go love on your mama. Go give a hug.
Focused on the fact that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms. And that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what they're saying the evidence shows.
You and my son must be related. He just got out of bed.
Then Elowen is somewhere within the room, not in his arm, not confined. I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elowen, however, it's the risk of any injury, including injuries to the ear or to Elowen's hearing. There is testimony about that in the light most favorable of the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find beyond reasonable doubt for the state. With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we're talking about injury to the welfare of a child, not
Do you not have school on Fridays?
the cases
Or
on this.
or did you get so much of your schoolwork done yesterday that you earned the day off today? That's the only way this mama bear would be okay with you sleeping. Or they gave you the morning off and you're going to work like crazy all afternoon. Which is it, boo?
crime that describe other versions.
Joking, not joking.
Have been convicted and those convictions have been held. Speak of situations involving, a caretaker getting high or drunk with a child in the car. Certainly while driving, but in other instances, just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Ellen's mother in front of her. Although he told the police that he didn't think she saw anything, he hoped she didn't. She told the doctor that mommy and daddy were fighting, daddy hurt mommy and me, and there was a lot of blood. In the light most favorable to the state, certainly it is clear that Ellen knows what happened. Ellen is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence sufficient at this stage that by shooting Caitlin in the head, the defendant endangered Ellen's welfare. We are not claiming that he injured Ellen beyond by shooting her with a gun. But when we're talking about endangering the welfare of a child, psychological injury or psychological welfare comes into play, emotional welfare, and that is what we're talking about here. It does not have to be evidence that Ellen is actually in therapy or that she's actually been diagnosed with a mental health issue for it to be shown that the defendant endangered her welfare by doing things that he did. The dual standard here that the defense mentioned is the standard. Purposely violating a duty and knowingly endangered the welfare. There's a case on that addresses it pretty well. Defense cited INRI NK. That case, I think, discusses that standard in a good way. Also, State versus Bortner. I don't have the site, I just have the name, but BORTNER specifically discusses the interplay between knowing purposeful, that is not a legal issue. And Bortner talks about a failure to act rather than an affirmative act. But
Cite on Bortner?
excuse me?
You have a cite?
I don't have one. I
Okay.
apologize.
No.
I don't have it on me.
Thank you.
But BORTNER, it's 150 NH. I forgot to
Okay, no, thank you.
write down the end of it. Knowingly endanger and purposefully violate. I don't think that it is in dispute that by shooting Ellen's mother in the head in front of her, that the defendant purposely violated the duty of care. He had to know. Anyone in that situation would know that that would seriously compromise and seriously risk danger to a child's welfare, psychologically and emotionally or otherwise. And purposeful violation of that duty of care that he owed to her. I think the knowingly engage in conduct speaks to the act. And we have already argued that the defendant acted knowingly. I think that's all the state has at this point. We ask that the motion be denied.
Okay.
Your Honor, 150 New Hampshire 504.
504, thank you. Okay, thank you. Attorney.
Just one comment, Your Honor. I think I said it in my motion that the state didn't offer any evidence of psychological injury or trauma or anything. It's speculation based on what it feels like. There was no evidence. And I'll leave it at that.
June, what do you mean no sound?
endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and the arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must
Not
construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State versus Wong, 138 New Hampshire 56, 1993, State versus Burke, 122 New Hampshire 565, 1982, and State versus Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss. With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony, referring to Mr. Duren, as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627.4, Roman numeral 2, at this point in the proceeding, I would find, once again, at this point in the proceeding, I would find that there has not been evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, that no reasonable trier of fact could have found that the defendant did not act in self-defense if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find under the no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that that takes care of the instant motion that is before the court. Attorney Kinney,
Yes, yeah, I think so.
anything further?
No.
Okay. Attorney Spicer, anything further at this time?
No.
No? Okay.
I think he's indicating no as to that motion, Your Honor, but we do have an additional
Okay.
motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No.
Okay. Attorney Durand?
Your Honor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumunden and/or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present along with Ms. Plumunden in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlin Nafziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumunden would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlin Nafziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently, based on some level pointed to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumundon and Ms. Nafziger, and that supposedly that Ms. Plumundon will be testifying to that plan, but the court believed, based on its reading of the transcript and based on some level of a value of fairness, that Mr. Duren was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan, and that he would need to have knowledge of such a plan, or at least of the desired result, in order for this information to be admissible. He would have to know that Ms. Plumundon was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said. And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material. But by its own ruling, the court has said Ms. Plumundon can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumundon and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Nafziger and for the support for these arguments that she was going to kidnap the children and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Nafziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Nafziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, And with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumunden with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Okay, thank you, Attorney Duren. Attorney Kittle?
Yes, Judge. I would reiterate all the arguments made in our objection, written objection in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we've discussed at length previously, that Mr. Duren was aware of the plan. I'll note a couple of things. I think that the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that like a statement that was made to Ms. Plumunden about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumunden's testimony about a current plan, it does apply under 8033. I'll just note a couple of things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Naxfer had this plan. Ms. Plumunden has told that to detectives, to our investigator. She sent a text saying you need to help plan a kidnapping. And so if the state's going to argue that kidnapping is a fabrication of the defense, that's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but the state said the door has been opened because there's been evidence of Ms. Naxfer's aggression. The state introduced that statement. The state pressed play on a video that had a statement about Ms. Naxfer's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duren, any response?
No, Your Honor.
Okay. Satisfied with the record relative to those issues?
Yes, Your Honor.
Okay. All right. I'm going to deny the state's motion to reconsider on that aspect. I've ruled several times on this matter. I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Oh, yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that. Miss Brenda Plumunden is our witness, but Miss Spurgeon, Trooper Pratt, Arthur Booten are all here in case we need to call them for rebuttal purposes. I do have a request before Miss Plumunden comes in, Your Honor, but it's about her testimony. When it's appropriate.
And I'm just going over my notes relative to the state's. Okay, again, I'm going to restate part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duren through Sergeant McLaughlin, it is clear that it several points in that statement, Mr. Duren referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time, after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Nafziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? There was a number of times in which Mr. Duren was asking what was happening to Ms. Nafziger, according to his version of events. And based upon the defense argument relative to the introduction of Ms. Plumond, am I pronouncing it correctly? Plumondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Nafziger, and not with respect to the reasons for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court, and I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Duran, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plumondon is here. Well, I believe she is. I haven't seen her today, but, okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that something might be said to cause a mistrial. So I'm asking for two things. Number one, for the court to have a colloquy with her outside the presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a natural desire to try to explain things. And I would like to be able to lead a very tight and specific questions to produce the testimony that you have deemed to be admissible. I will note that the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plumondon for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plumondon is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plumondon because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her, and now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered. But that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern, and I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form. Defense wanted decided to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions. There's no indication that Ms. Plumunden is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her, but the consideration.
If I may interrupt really quickly, the Zwicker letter says Ms. Plumunden was asked 2 questions and provided the answers to those 2 specific questions, and that is it.
Okay, so you talked to her though.
2 questions. What was Valen's date of birth? I do not know. Was Caitlin Nafziger breastfeeding? No. Those were the questions.
611-2, C2.
That's what I'm looking at.
Okay, when a party calls a hostile witness an adverse party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Plumunden about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I have not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So
Now I'm going to want to nap.
that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
Okay. Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duren, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay, all right, thank you. Okay, I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been number one, that she has been subpoenaed here, and that she's going to be asked questions, and that she's instructed to, is she prepared to answer the question that she is asked? Are you prepared to answer the question that you are asked?
So it looks like we may have a semi-hostile witness.
To limit your testimony to the question that was asked and not to volunteer further information. Is that sufficient, Attorney Kinney?
Hey, June, do we know what the movie's going to be tonight?
And Your Honor, I think it would
Got
also
any
be
ideas,
nice
June?
to instruct her specifically in accordance with your order that we're talking about the what of the plan and not the why of the plan.
And finally, that she's not to testify about statements allegedly made by Caitlin. That she can testify as to her perception, her understanding of what her understanding of.
Just a question for clarification, and it's why the state has asked so many times for the motion to be reconsidered. Is Ms. Plumunden then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Nafziger, or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Nafziger?
And I've already ruled that that relates to her understanding as to that, not relative to indirect hearsay. But she can't testify as to what Caitlin said to her, but she can testify as to what she understood the plan to be. Anything further, Attorney Keenan?
I see. Thank you, Angela.
Are we anything further right now?
No, Your Honor.
Okay. 10-minute break?
Thank you.
Okay.
Well, what do y'all think about them apples?
Breaking news.
We have some breaking news, y'all. Let me get it up. Sean Diddy Combs faced a brutal knife attack in Hell on Earth Brooklyn jail as he makes another bid for freedom. Jailed rapper Sean Diddy Combs was the victim of a terrifying knife attack at the hands of a fellow inmate who snuck into his cell and held a makeshift blade to his throat, according to friends. The disgraced friend of the disgraced music mogul, Diddy, 55, who was sentenced to 4 years behind bars earlier this month after being found guilty on 2 counts of transportation, engagement, and selling of oneself for acts and not keeping the money yourself. Ex-affecting is how I have to put that, I guess. I lost my place. According to Diddy's friend, Finney, the rapper has fallen prey to one of those acts of violence, having awoken in the night to find another inmate holding a knife to his throat. Speaking to the Daily Mail, Finney, who has known Diddy for more than 3 decades, said that the attack appeared to have been carried out as a warning rather than the actual assault itself, noting that the aggressor could easily have harmed the music mogul if he had wanted to. He woke up with a knife to his throat, Finney said, adding that it isn't the first time the music producer has been nearly injured in jail. I don't know whether he fought him off or the guards came. I just know that it happened. If the guy wanted to harm him, Sean would have been harmed. It only takes a second to cut a throat and a weapon to unalive him. It was probably a way to say, next time you ain't going to be so lucky. Everything is intimidation. But with Sean, it won't work. Sean is from Harlem. Finney did not reveal when the attack took place, although his recounting of the incident came just days after Diddy revealed that he plans to appeal his sentence and conviction. Lawyers for the musician filed a notice of appeal with the U.S. federal court October 20th, informing officials of their plan to move forward in the bid to overturn his convictions. The filing submitted by Alexandra Shapiro, does not specify the grounds on which the rapper's legal team will base the appeal, but his attorneys have previously argued that Diddy's conviction did not stand because the statute regarding the transportation for the purposes of selling of someone does not apply. Combs' lawyers have previously pled that the courts to transfer the music mogul and producer from the jail due to his long history of violence. Their concern didn't come out without cause, as the facility, which is the only federal jail in New York City, has been plagued with issues since beginning holding the inmates in 1990. At one point, the conditions were so stark that the judge even refused to send people to the center, which housed 1,200 detainees. According to the Associated Press, the prison features outdoor recreation facilities, medical unit, dental suite, and educational programs and library. Furthermore, 6 of the MDC employees have been charged with crimes over the last 5 years, while many were accused of accepting bribes or of supplying inmates with contraband, such as drugs, cell phones, cigarettes, according to the Associated Press. The conditions prompted Combs' team to call for the rapper to wait trial, which is expected to take 4 weeks until the house arrest in a swanky $48 million mansion. So he lost that. So thank you so much for that, Angela. Appreciate it. We're not sure what the movie is going to be yet. Yep. Yepers. Come on. I said pause. Okay, let me get back over here and get going. I'm ready for a nap. I may let this run and go take a nap. I've been fighting a nap all day. Only had 2 hours sleep. Oh, we already have one.
Sidebar.
I fall asleep. Somebody scream in my ear.
Up to meet Dustin, correct? Was, and so you and Shay.
Sure, thank you.
All rise for the honorable jury. Owen County Superior Court is now in session. The Honorable Jonathan S. Frizzell presiding.
Bailiff or clerk, please speak a little more clearly. That's all I heard. Thank you, Your Honor, for speaking clearly.
If I could have you raise your right hand. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
Okay. If I could have you state your name, please, and spell your last name for the record.
Brenda Plamondon, Plamondon.
Thank you.
Good morning, Ms. London. I just have a few questions for you. You live in New Hampshire,
Yes,
and you have 2 children?
3.
3 children. And Caitlin Nafziger was your niece by marriage?
Yes,
Okay. And Elwin and Valen are her daughters?
yes,
They never lived with you though, correct?
no,
In early of 2024, Caitlin reached out to you about coming to visit,
yes,
and she didn't give you much detail about her visit at that point, right?
yes.
So yes, she did not give you detail?
She did not give me much detail.
Okay, thank you. And in later February, she reached out again with information that she was going to come to New Hampshire.
Yes,
Okay. And you knew that she had a plane ticket to Boston, correct?
yes,
And that she was bringing the baby Valen with her, correct?
yes,
But you didn't know where she was going to stay, right? before she got to Boston?
Yes, that's true.
Okay. Or if she needed to borrow a car, right?
Right, I had offered.
You had offered, but you weren't sure. She never responded yes or no, right?
True.
Okay. But Caitlin and Valen did come to Boston in late February 2024, correct?
Yes,
And they stayed with you the first night they arrived
yes,
in Hampton?
yes,
Okay. And you and Caitlin and Valen stayed the night in Hampton. Was anyone else there?
yes,
Is that Shannon
yes. And my husband, Mark.
and your husband, Mark? Shannon is your friend?
Yes,
So that night at your home was the first time you really got to talk to Caitlin about her visit to New Hampshire, correct?
yes,
Okay. And that Caitlin was there, her plan was to go up and get Elowen and go back with both kids to Minnesota, correct?
yes,
Okay. And so you and Shannon and Caitlin talked about how that plan would play out, correct?
yes,
Okay. And you knew that Caitlin had a return ticket to Minnesota, correct?
yes,
And you would offer to pay for Elowen's ticket back?
yes,
Okay. So the plan was that Caitlin and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
no. Sorry.
Roger?
I've got a little girl under my chair. I couldn't wonder where she went. All of a sudden, I feel a little claw go. I got to trim her claws today. They're getting pretty tough. That's right, we can zoom.
Back to the airport. Okay, Ms. Clement, please review page 7, line 7 to 18, and then I'll ask you questions again of ID, defendant's ID, Exhibit D.
Okay,
So, again, the plan was to go to Berlin and wait for Caitlin and the girls to come meet you at a restaurant or somewhere and take them back to the airport.
no.
Okay, so can you tell us what the plan was?
that we were waiting for Caitlin to call us and tell us how she needed a ride, and that we would meet her wherever we needed to meet her. And if by Saturday we hadn't heard from her, that we were just going to go to Berlin and wait to hear from her so that we would be closer and ready.
And the plan was to get them back to Minnesota, all three, Caitlin, Valen, and Elowen, as quickly as possible.
Yes.
The next day, after that plan was discussed, you offered to drive Caitlin and Valen up to meet Dustin, correct?
Kind of.
Okay. Did you drive her up to Ossipee?
Yes.
Okay. And you drove with Shannon, Caitlin, and Valen, correct?
Yes.
Okay. And you drove Caitlin and Valen to the designated meeting place, which was a restaurant in Ossipee, correct?
Yes.
Okay. And Caitlin brought a suitcase with her, correct?
Yes.
She had a bag of like wet laundry because there was an issue with the dryer.
Yes.
Okay. But she did leave behind other things, right? Like her backpack,
Yes.
kids' birth certificates.
Yes.
Would you like a break?
Poor baby.
Okay.
Okay. I only have 3 more questions. You didn't see Dustin or Elowen when you dropped Caitlin Valen off, right?
No.
And after you dropped them off, you called Caitlin's mom to tell her what the plan was, right?
No.
Okay, you called folks though to talk to them?
Yes.
Okay. Those folks being her mom
Yes.
and her dad, Rob?
Yes.
Okay. I don't have any more questions, thank you. Where's the building? You're welcome, sir. Okay,
Yep.
there's some water there. Do you have some?
Yep.
Okay. Do you need to take a minute?
Nope, I'm okay.
Okay. Ms. Plumondon, you live in Hampton, New Hampshire, correct?
Yes.
How long of a drive did you have to come to court?
I don't know, like 2.5 hours, I think?
Are you familiar with this part of the state?
No, I'm not.
Had you ever been to Berlin, New Hampshire before?
No,
Have you still to this day been to Berlin, New Hampshire?
I have not.
Now, Caitlin Nafziger, she flew from Minnesota to Boston on February 27th of 2024, right?
Yes.
And then she took a bus to New Hampshire?
Yes.
And then you and or Shannon picked her up from the bus stop?
Yes.
She and Valen, her youngest child, they spent one night with you in Hampton, correct?
Yes.
Can you tell us during that time, did you have a chance to observe Caitlin and Valen together?
Yes.
What were your, without telling us what anyone said, what were your observations of their relationship?
What a good mom she was, and how relaxed the relationship was, and just how happy she was. Both of them.
Had Caitlin ever come to see you in New Hampshire before?
Yes.
How many times?
At least 3, maybe more.
How long had it been since the last time she'd been here?
We have a holiday called Thanksmas, and she.
Thanksmas?
Yes, and we
Okay.
do everything that we've always done, Christmas to Thanksgiving in 1 week, and all the family gets together. And so she was there for that, as was her mom and husband and other family members.
Her mom's husband?
Yeah, her mom Lori and,
Okay. Just making sure I know
yep,
who you're
yep,
talking
and
about.
Lori's husband Tim and my kids, and
Had Caitlin ever been to Berlin, New Hampshire?
no,
Not before February of 2024?
no,
Did she have any friends in New Hampshire?
no,
Were you her only relative in New Hampshire?
yes,
Besides her husband as well, right?
yes, yes,
And your kids?
yep,
And you, and I don't mean this to sound improper, but you're related to Caitlin by marriage, correct?
yes.
Now, on February 28th, so the very next day, I mean, Caitlin was in your house for, when did she get there on the 27th? In the morning? Or was it nighttime?
It was evening, and I was working and coming from Boston, so I didn't see her until like 5 p.m.
Okay. So at some point, sounds like less than about, I don't know, less than a day later, you drove Caitlin to that restaurant in Ossipee, New Hampshire, correct?
Yes,
A place called Harley Jack's?
yes,
Does it take, fair to say it took you over an hour to get there?
yes,
Had you ever heard of it before?
no,
Ever been there?
no,
When you got to Ossipee at Harley Jack's restaurant, Caitlin got out of the car?
yes,
She took Valen out of the car?
yes.
Was Valen in a car seat?
Yes, it was like a car seat that fits into the stroller.
One of
Okay.
those like dual, like
Right.
pop it in and out things.
Right, but
Okay.
she left the stroller portion at my house.
Okay. You didn't go inside the restaurant, right?
No,
When Caitlin got out of your car and took Valen, without telling us what she said or did what she said, how was she behaving?
I mean, it was quite a sad sight, and Shannon and I both cried. You know, she's such a small person, and she had this big, enormous suitcase, and, you know, she had the baby in the car seat, and she was just like lugging it. I felt awful for leaving her there.
But you did leave.
Yes, she specifically asked that we not come in because
So you left.
yes,
Okay. You didn't see the defendant at Harley Jack's?
no,
And just so we're clear, do you know the defendant?
yes.
How do you know him?
We have FaceTimed many times, and I, know him as the father of Valen and Elowen, and because of Caitlin's relationship with him.
You didn't talk to the defendant when when Caitlin was in New Hampshire, correct?
No,
You didn't talk to him in Ossipee in the parking lot?
no,
You didn't talk to him over the phone after you left Caitlin in the parking lot?
I don't even have his contact information.
He didn't speak to you?
No,
Did you leave before Caitlin went in, or did you watch her go in?
we left as we parked far away in the parking lot and left as she was walking through the parking lot.
So you didn't wait in the parking lot until they finished lunch and left the restaurant, did you?
No, I had no
Yes.
contact after she got out of the car.
And when you left the parking lot at Harley Jack's, where'd you go?
Home,
Okay, so you drove the hour back to Hampton?
yes.
You didn't follow them back to Berlin?
No, I was working and it was 5 o'clock, so I specifically, Shannon had driven up there, but now I was done working and I shut my laptop and I'm like, oh, I can drive home. And she's like, great, because I don't see well at night, so,
So you wanted to get home?
yeah,
You'd agree that your home is at least 2.5 hours away from Berlin?
yes.
Now, what defense has asked you about in terms of this plan is that you were going to, the plan was for you to go up and sit at a restaurant on Saturday, correct?
If we hadn't heard from her at that point.
Okay. Did there ever come a time that you heard from Caitlin?
No,
When you dropped her off in the restaurant parking lot, was that the last time you saw her?
yes,
As part of the plan, did you choose a safe word?
yes,
What was the safe word?
that,
Your Honor, can we approach?
Uh-oh, someone's not liking this. Interesting to ask to approach on that. What do y'all think about that? Do you find it as interesting as I am? I'm finding that quite interesting, guys. That is very interesting. Why would you get upset over a question about a safe word? Just saying. I got a homework assignment I got to get to work on.
Hours? Is that fair to say?
and call 911.
Was part of this plan to tell the defendant about it? Would that have made sense to you?
About the
tell him?
code word?
No, to tell him about the plan in general.
No,
Was Caitlin gonna tell him about it?
no,
Was your plan designed to hurt Elowen?
no,
Was your plan designed to harm either child?
no,
Was any part of the plan to seek money?
no,
Was there any part of the plan that had Caitlin telling the defendant that she was gonna call the police to take custody of the children?
no,
Was there any part of this plan that required Caitlin to tell the defendant that she was gonna take the children back to Minnesota?
no,
Did Caitlin have a car with her?
nope,
Did she have a rental car reservation anywhere?
no,
Did she have a bus ticket?
no,
Was Caitlin familiar in any way with the area in Berlin, New Hampshire?
no,
And the plan was that she would have the 2 children with her, correct?
yes,
Caitlin never texted you to say that she got into the restaurant okay?
no,
She never texted you to say the defendant was there?
no. She specifically said she couldn't text because he would control her phone.
She didn't call you to say that they were
Jackson
leaving the
here,
restaurant?
Ken.
No,
Did she send you any?
Sidebar. I knew that was coming. I knew, but she is allowed to be somewhat leading.
Approach, Your Honor.
She is allowed to be a little leading with this witness. The judge permitted it. But I don't know why the prosecution then is given hell.
She didn't call you to say that they left the restaurant, correct?
no, she did not.
Did she send you any photographs of her with the 2 children at his apartment?
No,
Did she text you at any time and say, help, please come?
no,
Did she ever text you a code word?
no,
Did there ever come a time that you heard from Caitlin after you dropped her in that parking lot in Ossipee?
nope,
Was that part of the plan?
no.
I have no other questions.
London, part of the plan was for Caitlin to take both children while Dustin was asleep, correct?
No,
That, you didn't discuss how he plays video games and stays up all night?
Objection, Your Honor, outside the scope.
Approach, Your Honor.
Again?
Sidebar.
Are you kidding me? Come on now. This is getting a little redundant, don't you think? Don't you think it's getting a little bit redundant? Yo. What are y'all thinking about this? Okay, so the movie is that. So you whistled at me to tell me the movie is going to be the Red Room at the Presidio. Is that what it is, June? This sidebar is insane.
Ms. London,
I am indicating that you should give it no weight whatsoever as part of your overall considerations, and you may rephrase.
thank you. Ms. London, is it fair to say that the plan was for Caitlin to get the girls from the apartment and leave without Dustin knowing?
yes.
Thank you. No more questions.
Very long sidebar, and then we've got this.
You've just testified that the plan was for Caitlin to leave with the two girls, correct?
Yes,
Without the defendant knowing.
yes,
Caitlin did not have a car,
right,
did not have a bus ticket,
right,
did not know the area.
right,
You were 2.5 hours away.
yes,
She didn't know anyone else in the state.
no,
It was February in Berlin, New Hampshire.
yes,
Fair to say the temperatures range between -2 and 32.
yes,
Whoa, that's cold, y'all.
Fair to say that it was snowing that week.
This is beyond the scope.
Overall,
I don't recall.
Okay.
I would remember if it was snowing on a week like that, if something going on in my life that was that serious. Y'all.
counsel approach, please.
Uh-oh. The honor. Your Honor, you want something. Red Room at the Presidio, based on a true story. Military investigative goes beyond his order to get the facts behind what appears to be a robbery motivated unaliving. What he uncovers sets off an investigation with shock and climax nobody could have imagined. Yes, I am going to watch that movie and do my homework. I got a paper that's due tonight. I got to make sure it's not by 5 o'clock. I got to check that in a minute. I need to get them back into testifying.
We'll reconvene court at 12.
Okay, so they have a long break.
to include just everything, even from like maintaining jobs, stuff like that.
And when did you start experiencing symptoms of your PTSD?
He's going to stand. He did it.
Real symptoms, probably once I got out of the Marine Corps. I guess, well, no, actually, probably not. I guess I'll rephrase that. Immediately afterwards, I'm questioning what I can say, but
The question in front of you, just, I think, ask it as narrowly, answer as narrowly as you can, is when did you first start experiencing symptoms from your PTSD?
okay, with that direct question, immediately afterwards.
Immediately after you were discharged from the Marine Corps?
Well, no, immediately after the event itself.
Immediately after the event itself?
Yes.
And what year was that?
2008.
That was while you were in Iraq?
Yes.
When did you get a diagnosis of PTSD?
Officially, this would have been 2021 or 22.
So after almost 15 years of experiencing symptoms?
Yes, yes.
When were you discharged from the Marines?
So this would have been 2011. I was honorably discharged in 2011
You were honorably discharged at what rank?
as a sergeant.
After leaving the Marines, where did you move?
I moved to Los Angeles, California, that's where I got my degree in audio engineering, and then I was almost immediately hired at Fox Sports as a post-production audio engineer.
Were you experiencing symptoms of PTSD or depression while you lived in Los Angeles?
Yes.
Where did you live after LA?
So afterwards, which this was just part of my sort of severe depression, but I ended up moving to Las Vegas, Nevada, and that made sense just for my work and also working as an event technician, so working at for like corporate events and music events in Vegas.
How was your mental health when you first moved to Vegas?
It was
Crappy.
Objection. Relevance.
Approach.
Oh my God. Even the judge was like, what? Even the judge was like, what? No. His mental health. I got to tell you, if you've got mental health problems, don't move to Vegas.
This was
Don't move to
unexpected.
Vegas.
So I was kind of anxious about it, but at the same time, I got pretty excited about just having a family, starting a family.
Had you always planned on having a family?
I did. Came a little early, but yes,
And was Caitlin pregnant with your daughter, Elwyn?
yes.
Did you and Caitlin move in together once you found out she was pregnant?
Yeah, so I don't remember the exact time, but it probably was around that time, April 2019, in which she moved in with me at my parents' house.
So you're living with mommy and daddy.
Were you involved during the pregnancy?
You're living with mommy and daddy, and you knock a girl up and you bring her home. You don't even have the ability or the courage or the balls to go out on your own with her. Dude, how old were you? 15?
Tried to be involved as much as possible. I was going to all the doctor's appointments, just trying to take care of Caitlin as much as I could. Just like her being happy makes the baby happy. So just, trying to take care of her as much as I
Oh
could.
my
as well.
God.
How was your mental health immediately before Caitlin
Before it was still pretty bad. I was seeing a psychologist. Not great.
Can you tell me what you mean by not great?
I was still dealing with some pretty bad depression, and just my life just kind of feeling meaningless or just really without purpose.
How was your mental health during Caitlin's pregnancy?
So it improved pretty quickly, with just being so excited about starting a family.
Did it make you feel
Ice maker sounded like a jackhammer again.
It was starting to, yes.
Tell us about the day that Elowen was born.
So it was December 2nd. So right away in the morning, Caitlin woke me up and told me her water broke, and we went to the hospital. The labor was long. It was about 13 hours. But once Ellen was born, she was placed on Caitlin's chest, and but immediately she was turning purple and wasn't breathing. So immediately I'm yelling at the nurses like, "Hey, something's seriously wrong here." They grab her, they take her to the side. They end up restarting, like she was started to breathe again. But then they ended up taking her to the NICU, to where she ended up spending a week there. Everything was fine, but they were just doing that as a precaution.
Where were you and Caitlin while Elowen was in the NICU?
So for the most part, we were with her. So we didn't really want to, obviously we wanted to be with her all the time. And then we would sometimes try to get back to the house just to like shower or whatever, try to get some sleep. And but yeah, for the most part in the NICU with her.
Tell us what it felt like the first time that you held Elowen.
It was beautiful. This was, hey, I have my first child. It was amazing.
When Elowen was discharged from the hospital, where did the three of you go?
We moved back with my parents at their house.
And this was in Minnesota?
Yes.
How did it feel to take Elowen home from the hospital?
Overall,
How did it feel to take Elowen home from the hospital?
Again, amazing. Again, it was, I just felt so happy just having this family, just being together as this family.
Did you spend a lot of time with Elowen when she was an infant?
All the time, as much as I could. Always being by her side. I mean, whatever, just, I don't know, bassinets, is that what they're called? Whatever, her, wherever she was sleeping, wherever she was, I always wanted to be near her, just always being with her. She actually had this little, it was like a little unicorn handkerchief or blanket, I guess. But she always had it since she was born, and she would make these noises like goy goy when she had it, and that we ended up calling it goy goy, and she still has it today, and that's still what we call it, her goy goy.
What did you like to do with Elowen when she was an infant?
Well, I definitely like to show her off a lot. Just going to see different family, friends. Yeah.
When she was an infant, were you worried about Elowen's safety?
Of course. I was always watching her, always protecting her, to where just even if she's on the bed, like, is something over her? Like, is she gonna roll over? Would she roll off the bed? Or like, if she's laying on the couch for some reason, is she gonna roll off the couch? I was just always watching her.
How long after Elwyn was born did you stay in Minnesota?
So this was about 6 months. So it would have been June, yeah, I think like June of 2020. And at this point, so I had talked about how I was only ever in Minnesota temporarily, and my plan was always to go back to Nevada eventually. And then, so obviously I got disrupted a little bit with Elwyn being born, but and then actually 2020 as well, that was during COVID. And so my work wasn't really available. Events were not really happening in Vegas. And so I was trying to find work, and it just worked out that I happened to find a job at the United States Postal Service as a mail carrier. So
let me just make sure this is clear. So you said you left Minnesota in June of 2020. Is
yes.
that when you moved to Vegas?
Yes, that's when I moved to Vegas.
And you moved there because of a job with USPS?
Yes.
Did Caitlin and Elwyn also move to Vegas?
Yes.
Were you looking for USPS for a long time?
Working for them, no. So once we moved there, this had a lot to do with how much a mail carrier, specifically in Vegas, was working at the time during the pandemic. To where there was a lot of work, learning or working long hours, like easily over like 12 hours, probably 6 days a week. And my depression started coming back. I think a lot of it had to do with just me not being around Elwyn and Caitlin. So I ended up quitting that around October, November 2020.
I'm going to ask you a little bit about your first Christmas in Vegas. Was Caitlin there?
No.
Where had Caitlin gone?
She flew back to Minnesota.
Did she take Elwyn with her?
No.
Who was in Vegas with you?
So it was just me and Elwyn.
How was your and Elwyn's first Christmas in Vegas?
So this was, again, to where my depression was coming back, and really that first morning, all I had was just this little Christmas tree. Is probably about a foot tall, and then just a couple presents. And I was really starting to feel just sort of worthless again, like almost like I didn't deserve her. I couldn't provide for her, didn't deserve her. And but
do you mean Elwyn? You were starting to feel like you
Elwyn,
deserved
yes. And but she was so happy, and her, just how happy she was, that became really just the most pivotal moment in my life. With everything I'd done, everything just paled in comparison to that moment of just, she became my everything, my life. And from that moment on, she was my purpose, my meaning in life.
Tell us about what Elwyn was like as a toddler.
Always happy, always run around, always learning. I tried to be good with always teaching her stuff. I remember sending it was a video to my mom, but she had flashcards to where they just had letters on them, like A, B, C, D, and then a picture of an animal on it. And I remember showing her, or recording this and just showing Elowen these pictures, or these flashcards, and her just rattling them off, getting them one by one, every single one of them correct, and just how amazingly smart she was, just even at such a young age.
How did you feel about being a father?
Again, it was amazing that it felt like that was my entire life, was being a father.
Were there any times when Elowen was a toddler where you were concerned about her safety?
There was a specific situation to where Caitlin was babysitting another kid. He was a little bit older, so Elowen would have been 2 or 3 at the time, and this other.
Objection, Your Honor.
Approach.
Sorry, I'm writing a demand letter for replacement for my ice maker. Hello?
And there's some blind.
I'm going to assume there were multiple incidents in Vegas that caused you safety concerns.
Yes.
Can you tell me about the last, maybe like the third one?
Okay, so it was at night. Caitlin was working that night, and so and this was late at night, so probably like 10 p.m. maybe. But Elowen and I were on the couch just watching TV. I think Elowen was asleep at the time, but I heard the doorknob sort of rattling, and and by the way, the living room was right next to the front door, and so I peeked back, and there's some blinds and a window behind me, so I peeked back and pulled the blind back a little bit, and there's a person right there trying to get into the house. So I immediately grab Elowen and I run upstairs and I set her down upstairs, and I tell her, do not move. And I end up grabbing my gun, going out to the door, and start yelling for the person to get out of here. And they really started banging on the door at that point, trying to get in. At one point, I did end up slightly cracking the door and showing, like flashing the pistol that I had and yelling at him, hey, you really need to get out of here now. At that point, they tried to stick their foot in the door, like kick the door open. I was able to slam it shut on them, lock it again. At that point, that's when I ended up calling the police as I'm standing in front of the door. And within that conversation, they said that they're on their way. I do remember specifically they're asking about the gun because I told them that I had one out, and I specifically told them I'd put it away when they arrived. but it took them about 30 minutes to get there. And by that time, this person had left. And so they did eventually show up. I walked outside with Elwin and just sort of talked to him a bit. We tried to get some Ring doorbell camera footage, but we ended up not being able to see anything.
But the police didn't respond in time to address the threat or catch the person.
No.
At some point, did you and Caitlin decide to leave Las Vegas?
So, yes. She didn't really like Nevada. I did, but I basically was saying, okay, if you don't want to live here, convince me where we should move. And over the course of probably about 1.5 years, we went over just a bunch of different places to move to. But she had suggested early on about New Hampshire, specifically because her Aunt Brenda lived here, and she thought she could get work through her. And that was eventually what we decided on.
When were you planning to move to New Hampshire?
So this would have been, at the time we were renting a house, and our lease was going to be up August 1st. So that was going to be the time.
August 1st of what year?
Oh, this would have been 2023.
What steps had you taken together to move to New Hampshire?
So we had been talking about it for a long time, but closer to it, I ended up ordering some pods, like U-Haul storage pods that they bring to the house, and then you pack them up and they ship them out. But I had ordered some pods, brought it to the house, or had it being brought to the house to pack up all our stuff and eventually move there.
Did you think that you and Caitlin had agreed on a plan to move to New Hampshire?
Yes.
And whose idea was it?
Caitlin's.
Would you have been happy to stay in Nevada?
Yes.
How were you planning on getting to New Hampshire?
So the plan was for me to basically drive, and I had a very long road trip planned out. Actually, I had two planned out because I had a southern route and a northern route. But Elwin and I driving out, and then Caitlin and Valen would then fly out.
Why were you going to drive with Elwin while Caitlin flew with Valen?
I guess specifically, I didn't think Valen at that point, she would have been about 6 months old. I didn't think that she or really anyone would be able to handle a long road trip.
I think I skipped an important event in your life here. When was Valen born?
Oh, that was January 17th, 2023.
And Valen is your and Caitlin's child?
Yes.
Was she born in Vegas?
Yes.
And so your plan was for 6-month-old Valen to fly to New Hampshire with Caitlin while you drove with Elwin?
Yes.
Did the four of you move to New Hampshire in August 2023 as planned?
No.
What happened instead?
So before the pods I'd ordered have arrived, a different set of pods showed up, and I was upstairs at the time, and I heard a truck outside and was confused about what was going on. I didn't know if there was pods were there, if they were just coincidence that it was someone else's pods, or if ours had arrived early. But anyways, I go downstairs to go check on it, and Caitlin is in the kitchen, and I tell her, hey, there's pods outside. I'm gonna go check out what they're about. And she says that they're hers. And this was really the first time I found out that no, she was not going to New Hampshire, that she was going back to Minnesota.
And had you been aware that Caitlin was planning on going back to Minnesota?
No, that was the moment I found out.
What did you do when you found out that Caitlin was going back to Minnesota?
I was pretty distraught. I didn't understand it. I was pretty upset just about how and why she was breaking up the family. I didn't understand it.
Did you and Caitlin come up with a plan about what would happen with the kids when she went back to Minnesota?
No. So I was trying to talk to her about it, about what the plan was. And again, just being really distraught about just what was going on. Was she going to just go back by herself, and she was gonna leave the kids with me, or is she trying to take both, or are we splitting the kids? And any one of those options I didn't really like, but she just wasn't responding. She just wouldn't have that conversation with me.
What happened when Caitlin went back to Minnesota?
So she ended up just going outside with the stroller, like she was going to the park.
Who was in the stroller?
Valen. So Elowen was at daycare at this point. She was in like a preschool daycare kind of thing. And so she took Valen out into the stroller and just was kind of walking like going to the park, and which was normal. I mean, we went to the park all the time, so that seemed like a normal thing. She didn't take anything. She just left like she was going to the park. And a couple hours go by, and she hadn't come back, or I didn't hear anything. So I ended up going to the park, and no one was there. So I texted her, "Where is she?" And she responded that she was at the airport with Valen.
Had Caitlin previously told you that she was taking Valen to the airport?
No.
And did Caitlin tell you where her and Valen were going to go once they got to the airport?
Well, they were going to Minnesota.
Had Caitlin told you she was taking Valen to Minnesota?
No.
Had you given permission for Caitlin to take Valen to a different state?
No.
What did you do when Caitlin told you that she was at the airport with Valen, about to take your child to a different state?
So I freaked out. I immediately drove to Elowen's daycare because I wanted to see if she had grabbed Elowen too. And so I went there, and no, she wasn't. Elowen was still at the daycare. So I picked her up and then sped to the airport. And as I was doing that, I was calling my parents. I called her dad, Rob, just trying to figure out what was going on. And it seemed like no one knew what was going on.
Did you talk to Caitlin again that day?
So eventually I did get her on the phone, and this was while I was still driving, and she said she wasn't going to come back through security because, and I started telling her I at least want to say goodbye to Valen and for her to at least say goodbye to Elwyn. But she just said she wasn't going to go back through security. And eventually, I guess I just gave up on it and turned around and headed back to the house.
When you headed back to the house, did you talk to anyone else? Or did you continue to talk to other people about what to do?
Well, yes. So, I ended up trying to figure out just basically what to do, but I was talking to like my family and Caitlin's family just about what was happening and what the plan should be. I figured, well, okay, if we're not going to New Hampshire, I'll just stay in Nevada because I just like Nevada. I like the desert. I like being there, so I figured I would just stay in Nevada. But they were all, both my family and her family, they're all trying to convince me, hey, come back to Minnesota. We'll all be together. We'll all try and figure this out together. And really, I didn't make up my mind until July 31st, really the day before I left. And because I had already had an apartment secured in Vegas, a new apartment. And, yeah, I eventually decided to go back to Minnesota, really on the point that I did not want Elwyn and Valen to grow up separately. That really bothered me.
How did you get back to Minnesota from Vegas?
So Elwyn and I, we made a nice road trip out of it. Spent several days with a friend of mine in Utah and just doing this whole road trip. That was just this another incredible bonding experience. Yeah.
Once you got back to Minnesota, where did you live?
So I ended up moving back in with my parents.
What about Caitlin? Where did she live?
So she was living with a friend of hers.
How far apart was where you lived and where Caitlin lived?
If I'm remembering right, it was about an hour and a half.
Where were the girls? Where were Elwyn and Valen living when you were both in Minnesota?
So we were splitting custody to where there'd be times to where she was with Caitlin. The girls were with Caitlin, and then times where they were with me and my parents.
Who were they with more?
I think the total number came out to be 98 days with me and my family, 48 days with her, and then a random like 15 days to where the kids were split for whatever reason.
When the kids were moving between the two households, how did they get from one place to another?
So I would normally drive, which I was fine with doing, but I would just drive and drop them off or drive down there and pick up the girls. But eventually we ended up figuring out a restaurant to kind of meet in the middle, and then that generally became our spot to exchange the girls.
Did you try to come up with a more permanent plan for where the four of you would live?
So yes, specifically in October, I had a meeting at the same restaurant that we would normally meet at with Rob, her dad, and we tried to plan out, or basically, okay, I asked her just point blank of, hey, can we just continue our trip to New Hampshire? And she immediately said yes, and which kind of surprised me because I thought I would have to try to convince her somehow, but she just immediately said yes. And from that point on, that's when we started planning to eventually continue the move that was planned to New Hampshire.
Just gonna ask a couple clarifying questions. You said this meeting was sometime around October. Was this October of 2023?
Yes.
And then you said, you asked if you could continue your trip. By that, did you mean your move to New Hampshire?
Yes.
Were the four of you going to live together in New Hampshire?
I would not have been opposed to it. I'm just someone who's really big on the nuclear family, and I feel like it's really, really important for children to grow up with both parents in the household together, everyone living together. And so I would not have been opposed to it, but at first the plan was that we would live separately.
And when did you decide to, or when did you plan to move to New Hampshire?
So this was October, so we were deciding that we would wait until after all the holidays, and so like Halloween, Thanksgiving, Alwyn's birthday on December 2nd, and then Christmas, New Year's, and then Valen's birthday on January 17th. So we'd wait for after all the holidays, spend the rest of the time with family, and then after Valen's birthday, then to start the move.
Was the plan for all four of you to start the move at the same time?
So no, I would go out there first with Elwyn, get the place secured and just kind of get set up. And then Caitlin would then fly out with Valen, and we worked it out to where she would drop Valen off to me, and then she would go back to Minnesota just to kind of get money and just kind of work on what she needed to do, free of not having to worry about the girls. And then once she got some money secured, then moving a few months later, when her Aunt Brenda would have seasonal work for her.
And why didn't you just take both Elwyn and Valen with you initially?
Again, the road trip, I thought it would just be too much. But I did know previously, just because of Elwyn's and I's road trip from Nevada to Minnesota, which she did fantastic with, that I knew that she would have a really easy time, and we'd have just another great bonding experience kind of doing this road trip from Minnesota to New Hampshire.
And you said you thought it would be too much. Did you mean too much for Valen?
Well, yes, but probably me too, trying to do a road trip with two young girls, like a 1-year-old and a 4-year-old at the time, yes.
And Valen was one at the time of this
Yes, yes.
What did you do to get ready to move to New Hampshire?
So I had, again, ordered pods, just sort of packing up all the girls' stuff. As we were doing this, Caitlin was bringing me some of the stuff, like Elwyn and Valen stuff that she had. Like during Valen's birthday, we went to the Mall of America. But anyways, when we met there, then Caitlin brought kind of the remainder of Elwyn's stuff that she had, and then some of Valen's stuff, so that I could put it in the pods to be sent to New Hampshire. So she did that, and then two, I showed her because I had gotten the apartment by then, and so I was showing her pictures of the apartment and where we were staying, and that it was going to be the place in Berlin, the apartment in Berlin.
Did you give her the address?
Yes.
So you said you had decided to leave for New Hampshire after the holidays, the last of the holidays being Valen's birthday?
Yes.
And what day is Valen's birthday?
January 17th.
Your Honor, may I approach the witness?
Certainly, certainly.
I'm going to show you what's been marked for ID as Defendant's E. What is that?
It's a January 2024 calendar.
Is there more than one page?
Yes. So it's also February and March 2024.
Can you please mark Valen's birthday, January 17th, on the calendar?
Yes.
Did Caitlin book a flight to New Hampshire?
Yes. So this was before I left. She ordered a flight out to Boston. Yes.
And how did you know she had gotten a flight to Boston before you left?
Pretty sure she texted it to me. I'm pretty sure the day before we ended up leaving. Elwin and I.
What day did Caitlin text you information about her flight?
I mean, I don't recall exactly, but I guess maybe the 19th, January 19th.
Would it refresh your recollection if I showed you copies of the text between you and Caitlin?
Okay.
So I'm going to show you what's been marked for ID as Defendant's Exhibit I. What does that first message show?
It shows the,
Your Honor, that is supposed to refresh recollection.
Existing.
When did Caitlin text you her flight information?
that was January 19th.
And what did she text you specifically?
She texted me a screenshot of the flight info.
What dates are on the reservation?
The 27th, I believe it was February 27th.
Was there a return flight?
Yes.
What date was the return flight scheduled?
The 5th. Yeah, I think it was the 5th, March 5th.
And whose name is on the reservation?
Caitlin's.
And again, she sent you that text on January 19th.
Yes.
Can you note on the calendar that I've provided when Caitlin sent you her flight information?
Okay.
What day did you leave Minnesota?
So that was the next day, January 20th.
And you left with Elwin?
Yes.
Can you please mark on the calendar the day that you and Elowen left Minnesota?
Yes. Okay.
Had Caitlin been with you, or I'm sorry, had Elowen been with you the night before you left for Minnesota, left from Minnesota?
No. So I had to pick her up on the morning of the 20th.
Where did you pick her up from?
So this was this was at her friend's house. So I drove over in the morning, went to her friend's house. She was the one that opened the door. I guess I could say the name, Sarah, but saw her, just said a brief greeting, just hey, and then she went upstairs, and I went inside, just met with Caitlin for a little bit, and we all came out together to the car. I had it just packed with all sorts of stuff for the road trip. Like my mom made Elowen a picture book, but just road trip ready. And then basically I said goodbye to Valen, and Caitlin said goodbye to Elowen, and we started our road trip.
Before you started, had you sent any messages to Caitlin that day,
Before?
before you left?
Yes.
And why did you message her?
It was just to figure out where I was picking up Elowen.
And did Caitlin send you an address to pick Elowen up?
Yes.
She sent that via text?
Yes.
Did you text her again to let her know when you got there?
Yes. To Sarah's house? Yes.
Yeah. Were you and Caitlin in touch while you and Elowen were on the road trip?
Yes, the whole time. Actually, immediately afterwards, it was about 10 minutes after I started the road trip, Elowen just started vomiting in the car. And anyway, so I immediately had to pull over and take care of her. And I texted Caitlin about, hey, Elowen's throwing up in the car. What is going on? And she texted back just something about how, yeah, Elowen had been sick.
Stayed.
Were you and Caitlin in touch in other ways while you were on the trip?
Yes, so I had been calling and we were FaceTiming and just kind of showing our adventures throughout the road trip.
Were there any other subjects that you communicated about while you were on the road trip?
I think again she was asking for some more money. I had been just sort of regularly sending her money. It wasn't a ton, but it was just kind of what I could afford, like a few $100s every month, like maybe like $500 one month or $100 the next month. But yeah, I think she was asking just for some more money.
And how did you respond?
As to who responded, as to Caitlin respond?
How did Dustin respond to Caitlin?
Okay.
May we approach?
Yep.
Defendant's Exhibit F. You can take that. What is that?
It's a picture of Elwin and I at Niagara Falls.
And was that picture taken while you were on your road trip?
Yes,
Is it a fair and accurate representation of what you and Ellen looked like and where you were on your road trip?
yes,
Did you text that photograph to Caitlin?
yes.
And when did you text it to her?
I believe it was immediately after we got to the house.
So after you got to New Hampshire?
Yes.
And why did you text that photograph to her?
Overall, overall,
Really, I just wanted to show what we were all doing. Obviously, I wanted to keep Caitlin informed on just what was going on and what we're doing.
And was it just one of a series of photographs that you sent to Caitlin from you and Elowin's road trip?
Yes.
Judge, I've moved to strike the ID and that Defendant's Exhibit F be entered as a full exhibit.
over the state's objection, the ID may be stricken and it shall be considered as a full exhibit.
Permission to publish to the jury?
Yes?
Members of the jury, I'm going to ask you to pass this photograph.
Fifth, January.
This photo of you and Elowin, Defendant's F, you said that you sent it to Caitlin?
Yes.
Did you send it to anyone else?
Yes. I'm trying to remember exactly who. I think my parents, I think, and I think both of Caitlin's parents as well.
Both Lori and Rob?
I think so, yes.
Do you still have that calendar up there?
Yes.
What date did you arrive in New Hampshire?
If I'm remembering right, I actually think it was the 25th, January 25th.
So that's different than the date that you guessed when you were, or mentioned when you were talking to the police?
So, yes, the more I thought about it, the more, I'm pretty sure it was the 25th, not the 23rd.
Can you write the date you arrived in New Hampshire on the calendar?
Yes. Okay.
Where was your apartment?
So it was in Berlin.
Was it on 1063 Main Street?
Yes.
How was the apartment when you arrived?
So we arrived a little early, so it needed some cleaning, but anyways, we did some deep cleaning and then got kind of what we had taken in the car set up and ready for the pods to arrive to really get settled in.
Did you set up your bedroom?
With what we had, yes.
And did you set up the girls' bedroom?
Yes.
Did you do anything else to get settled in?
Quite a bit, just to get settled in New Hampshire. I had to get new driver's license, new registration on the vehicle, new license plate. I got Elowin enrolled in the Berlin Head Start, the preschool that's right there. And we were regularly going to like the Berlin library. But yeah, just kind of getting all that taken care of.
Did you send anyone your address?
Yes. Yes, Rob was asking to send Valentine's Day cards.
Did you ask Caitlin before sharing the address with Rob?
I did. Actually, I take it back. It was actually right afterwards. But I did ask Caitlin if I could share or if she had an issue with me sharing the address to anyone.
Did she?
Objection, Your Honor, relevance and hearsay.
Sustained.
But you testified earlier that you had, Rob, Caitlin's dad, had wanted to send some Valentine's Day cards.
Yes.
Dustin, where in the house do you keep the Valentine's cards?
I set them in the living room, and it was on a little,
Finally,
like a black drawer. I set them on top of it.
Were they in one of the photographs the state introduced?
I believe so, yes.
fan. I just feel it.
Was it maybe visible in a video that was played?
Maybe.
Okay.
That might have been it.
For everyone's sake, I'll stop trying to find it. How were things with Caitlin once you got to New Hampshire?
June, why are you typing like it was me? Y'all, that was on June. She's sharing under my name. Boo. That'd be on your kitty, not mine.
So they were all right at first, but she was really having money issues, and so she was continually asking for more and more money.
Did you have an argument about money?
Yes, so this was February 14th. She really what a lot of it was about money, but it also included how she wanted to put Ellen and Valen on her taxes. And I didn't even say no, but she just didn't even like that response. So she started making a lot of threats about how she was going to say that I kidnapped Elowen and took her to New Hampshire without her permission.
Let me ask you, had you done that?
No.
And your understanding was that Caitlin had given you permission to do
Yes.
that? And you had been staying in touch with Caitlin along your journey
Yes.
and sending her parents your address?
Yes.
Who did she say she threatened she was going to call and falsely make these claims to?
To the police.
What else? Anything else happened during that argument?
Along with that, just threatening that she would take the girls away from me and I'd never see them again.
Not trying to be mean, but this is one thing I hate about divorces. Yes, it was my kitty, not mine. Is what I hate about divorces is the fact that one, if not both people at one point will pull and play those kids against each other and threaten like this. And it's so not okay. Does not matter what's happening. You don't do this. My ex did it to me, and I'm like, dude, I got full custody. You don't. You in prison. I take these kids when and where I want to. You have no say. He thought he did. I mean, he had minor says, but in the end, it was all on me. But threatening to take someone to the police over, I have zero patience.
And how did that argument impact you?
Look at this.
The plan that you and Caitlin had for Caitlin to bring Valen to New Hampshire?
So at that point, I wasn't sure what was happening. Now it sounded like she was not going to bring Valen to New Hampshire. So I start making a bunch of calls immediately.
Let me back you up there for a second, okay?
Yes.
You said that argument was on February 14th,
Yes.
and is Caitlin's phone number 612-900-4997?
Yes.
Let's take a look at the cell phone records that the state introduced into evidence from here. States 13.
Sorry, I had to go to the girls' room. What is this constant sidebar crap? Breaks and sidebars. That's all this courtroom does.
And we heard testimony earlier about what your mom's phone number is. That next line, line 38, is that your
Yep.
mom's phone number?
Yes, it is.
So did you call your mom? Is that
Yes.
that you called your mom?
So yes, I did call my mom, yes.
And what time did you call your mom?
That was 4:09
Line
PM.
4:09 PM. And then that next line, what does that show? So we've got who the call was made to, and then who the call was made from afterwards.
So that's my mom calling me back.
And then lines 40 and 41, who's calling you back there?
That's the Minnesota attorney.
What time did the Minnesota attorney call you back?
It's 4:18 PM.
Line 42, who do you call?
That again, that's the attorney.
Is Lori Smith's phone number 763-381?
Sustain.
May we approach?
Sure.
Sidebar.
Call your mom again?
Yes.
And what time did you call your mom?
5:32 PM.
What's the phone number you called on line 48?
It is 612-221-2078.
And so that's the same area code as Caitlin's phone number?
Yes.
Do you remember whose phone number that is?
And that is potentially Lori's.
But you're not sure?
I'm sorry. Yeah, I'm not sure.
That's okay. Does it show what time you called someone with the same area code as Caitlin's phone number?
6:45 PM.
And is that the last call you made that night?
Yes, it is.
After that argument, when's the next time that you and Caitlin communicated?
So it was almost a week later to where Elwin, it was the first time that Elwin went to the Berlin Head Start, the preschool. And so she was pretty excited about it and wanted to talk to her mom, talk to Caitlin, and tell her about it.
And how did you communicate that to Caitlin?
So I texted her about how Elwin wanted to.
John, I apologize.
No ruling.
Sorry, can you say it
I
again?
can try to ask the same question again. How did you communicate to Caitlin that Ellen wanted to talk to her?
So I texted her that Elwin just had her first day at the preschool and that she wanted to talk to her.
Did Ellen and Caitlin talk that day?
I don't think so, no.
What, if anything, did you offer to do for Caitlin after the argument?
So eventually, just because I was worried about this, well, actually, I'll back up a minute. I hadn't seen Valen, and so I want to see if she was okay.
Non-responsive.
Overruled.
I was checking on Valen, wanted to see if she was okay, so I texted Rob, her dad, and just to see if he could go over and check on Valen and just see how she was, which he did, but he said that he didn't actually see her, that Valen was sleeping, and that he just didn't want to push the subject, so he just kind of left it alone.
And how did that make you feel?
So obviously a little disappointed, but yeah.
And did you offer to do anything for Caitlin at that point?
So at that point, I was just thinking, okay, if I can just text her and say, okay, you can claim Ellen and Valen on your taxes, and if I just say that that's okay, will you still bring Valen to New Hampshire?
The names are getting me.
And she said yes.
Did you do anything else to make sure that Caitlin would bring Valen?
So I did, I think I had already done this actually, but I did reimburse her for the plane ticket. And I was still sending her what I could, money-wise.
What else did you do after the argument?
I guess I can't think of anything specific afterwards.
You testified earlier you had talked to your family court or your child custody.
Oh, yes, yes.
Can you tell us about what you did in relation to the
Okay, well,
family lawyer? Or, I'm sorry, in Minnesota.
yes, the
the
Minnesota
family lawyer in
attorney, yes.
Minnesota.
So I was trying to retain her, so I was paying her hourly, but I wanted to retain her just because, again, I was worried that something was going to happen. So I was trying to get a retainer. She was needing $4,000, and I was tight on money, especially with the move. So I was trying to figure out what to do. I was thinking about selling my car, but didn't actually do it, and then was trying a credit union, and my credit wasn't that great at the time, so got denied for that. I was just trying to figure out ways to make it work.
Were you able to retain the lawyer?
No.
Did Caitlin end up coming to New Hampshire?
She did, yes.
And did she bring Valen?
Yes.
As far as you know, where was she staying when she got here?
As far as I knew, with Brenda or one of her rental properties.
One of Brenda's rental properties?
Yes.
Had you offered to let Caitlin stay with you?
I did. I texted her about how I kind of figured that.
I wish we could have jury questions. Some trials and judges and courts allow jury questions. This would have been awesome.
She would.
Yes.
Sidebar.
Sustained in part, subject to rephrase.
Had you offered to let Caitlin stay with you?
Yes.
And did she take you up on that?
And she said no.
And without saying the content of the messages, how were you aware that she did not want to stay with you? Or that she had, why did you think she didn't want to stay with you?
Objection, Your Honor. I'm just, in terms of phrasing of the question, I'm not sure how we get to that without hearsay.
Your Honor, may I approach?
Yep.
I can't go and do anything without this court going on sidebar. Really? End of day. How much you want to bet?
You need to look at the calendar, let me know. But what day of the week was February 28th, 2024?
Wednesday.
And what were the sleeping arrangements that night at your house?
So my bed was set up in just my bedroom, and then I had an air mattress that I got for Elwin and I before our pods arrived, just for something to sleep on. But then, so I slept, myself and Valen slept in my bed, and then Caitlin and Elwin slept on the air mattress.
What did you do the next morning, Thursday the 29th?
So right away in the morning, I made breakfast and we went to the public library. It just happened to coincide with bi-monthly, they had a arts and craft, like kids arts and craft thing at the public library. So we went there just as a family and just went through the story time, and Ellen made just the character from the story with like cotton balls and glitter and stuff like that.
I'm going to show you States Exhibit 8. Can you see that craft you described with pom-poms or cotton balls? And
Yes, yes.
where is it?
So it's right in front of the coffee maker on the far left of the picture.
Can I publish to the jury too?
Sure, Attorney Kendall's, I think, which one of 8?
States 8,
Is there a specific letter on it?
maybe O? Yeah, 8O.
8O, okay. Thank you very much. Certainly.
Where did you go after children's story time and arts and crafts at the library?
I went back to the house.
Your Honor, may we approach?
Okay, certainly.
Sorry, I have to print something for my son. Yes, batteries. They don't last long enough, man. Good day, Hilda Bay. How's you doing, Hilda Bay? We haven't seen you in a while, Hilda Bay. You're coming in at the end of the day. And
Instructions, and I appreciate that. Because it is going to be over a weekend, we will start again 9 o'clock on Monday.
8
Between now
o'clock
and
next
then,
time.
please do not discuss the case with yourselves or with anybody else. And I realize that we're going to be, it's going to be a 2-day break, but please discuss the case with nobody else. Please don't do any research about anything that you've heard about as part of this proceeding, including any online research, any visiting of any locations or anything like that. Take no action in that regard whatsoever. Again, there is a media presence here. Please do not research any aspect of this, and please go so far as to avoid any interaction with anybody relative to the content of the media coverage as well. Please try to avoid any inadvertent exposure. And with those as the instructions, and again, I appreciate your attentiveness to these instructions. We'll resume again 9 o'clock on Monday. And with that, I wish you a good weekend and take care. Mr. Duren, you can step down if you like. Because Monday may end up being accelerated relative to the number of things that have to be done over the course of the day, my intention is to get to you folks a draft of the second half of the jury instructions with the understanding that it is completely, and I emphasize this in the greatest possible terms, a rough draft, but I recognize everyone's ability to prepare zealously with respect to their specific positions. I want to get a rough draft to everybody when I can, with absolutely no indication one way or another of how I'm ultimately going to rule, but I want to make sure that I've got at least a structure out there and a format so that counsel can at least be prepared to make their arguments and see at least the general format of how I intend to instruct. Obviously, there's still testimony to be received. I have not made any decisions because the evidence has not closed, and I have not heard counsel's arguments with respect to everything, but I would rather start that process with the understanding that it is completely rough draft, subject to both legal argument and factual argument and the close of evidence not having been completed. Any objection to starting that process from the state?
No, Your Honor.
Okay, any objection from defense?
No, Your Honor.
Okay, once again, I know folks will need to tailor we need to have a long charging conference and we'll need to tailor closing arguments with respect to the instructions, so I want to give you enough time to do that so everybody's doing their job, okay? Anything further before we break for the weekend?
No, Your Honor.
Okay, all right, thank you very much. Have a good weekend.
okay, there you go. I'm gonna watch a couple of these people come out of the courtroom. Matt, I got your paperwork and your belt is on the dryer. Why did I lose my background? That's unusual. What? And if I said I have a green screen, it should stay. Everything's been glitchy this week. I gotta be honest with you. Everything's been glitchy. Glitchy. Okay, let me do a recap. All right, y'all ready for this? Bum, ba-dum, bum, bum, bum. I know. It's okay if you see my green screen. It's all real. Life is real, y'all. Okay, for those of you who are not sure what's going on, this trial is Dustin Duren, aka the Amber Alert Redrum trial out of New Hampshire, charged with second-degree redrum, reckless conduct, and deadly weapon with child endangerment. The victim, Caitlin Knapzinger, the mother of Duren's 2 daughters. The defendant, testimony. Duren took the stand today. We just saw that in his own defense, describing his background as a Marine veteran with deployments to Iraq and Afghanistan. Look, I understand all respects to anybody who deploys, and I have the utmost of respect for those with post-traumatic stress disorder. Some of us are disabled with PTSD, and the thing is, it's real, but I think too many people now use it as an scapegoat for criminal activity. Just saying. Detailing struggles with depression, employment, and emotional regulation. Duren spoke about his relationship with Caitlin, which began in 2019 and then started deteriorating after their separation. Thus causing their separation. He claimed that Caitlin had threatened to take the children permanently, kind of resurfacing the past incidents where she had left with one daughter without informing him of where they were. Duren said he feared Caitlin would disappear with both girls. He described the feelings of helplessness and overwhelmed. So the defense's strategy framed the redrum as a desperate act by the father in crisis, not as a calculated redrum. Argued Duren believed Caitlin was attempting to kidnap the children, triggering a PTSD-driven response. I'm not saying that can't happen, but that use of that PTSD often, here you go. That's a marker. Here you go. Often is an excuse and not reality. Just saying, emphasize, that's my humble opinion, emphasized his emotional breakdown on the stand and his constant concern for his daughters and their safety. So the prosecution center on Duren's admitted that Caitlin was not threatening him, nor were the children at that time of the shooting and the redrum in danger. Pointed to the lack of close range indicators at Duren's own words that that the shooting was deliberate, that he did this on purpose. Suggested that the motive was more anger and control, not fear. The evidence, Caitlin was shot in Duren's Berlin apartment on February 29th of 24. Duren fled with the children, prompting an Amber Alert. He was later arrested hours later at an Applebee's parking lot 170 miles away. Earlier in the testimony, it was revealed that Caitlin had planned to take the children to Minnesota with help from her aunt, using a secret code word to avoid alerting Duren. So what's next? Duren will continue to testify on Monday, the 27th. The court is expected to hear from mental health experts, child welfare officials, and the Amber Alert coordinators. Y'all, this is interesting. Very interesting. What are your humble opinions? So, we are at the end of day. It's been a weird couple of days for trial. This week has been weird. I missed you too, honey boo. It was not fun. This time last week, I was like, I got to get to work. This is a no bueno. No bueno. Okay, guys. I want to say thank you to our fabulous mods. Nightbot. No, I'm kidding. June, you're fabulous. Angela, you're amazing. Honey, thank you so much. I'm trying to think who else was in here today. Amy, you've been fabulous. All of y'all are fabulous. Just really, really appreciate all of you. Thank you guys for hanging in there and being with me. Nobody important. I don't like that name. I'm telling your mama, y'all need to change it. You probably should put, I'm a somebody important. I know why you did it, but you don't speak out there. It'll come back. Words have power. I'm a nobody important. That's wrong. You are somebody important. I hope you can change that. I don't know. That's just my humble opinion. And I'm sticking to it. I'm a somebody important. That's more impressive. I like that. I'm a nobody importance too. Use kind. Use smart. Use important. Thanks from the movie The Help. That's one of my favorite sayings now. All right, let's do this. I need to get my music. Because we are going to I don't want I need the music. We are going to play the game. Are y'all ready? Ooh, I like it. Y'all ready for bingo or just in general? Okay, we're going to start with this morning. Congratulations, June. Yay! And with an E. No. You can't win. All right, here we go. Good luck. I love the fox or whatever that is. Oh, that's not a fox. What is it? I forgot. Chinese something.
Mama, you got somebody. Oh. Honey. I'll do one more because we had so many. Amy Evans. Woohoo! And one last one. We had enough. One more and that's it. We ain't gonna get that, Angela. Yay! Congratulations. Thank you so much, everybody. That is awesome. Thank you for a fabulous day. One happy day. It's been a day. It's been a week, and I'm glad it's over. The trials have been kind of weird lately. A lot of sidebars, horrible audio in some of the courts. I mean, when I'm 100% gained up over here, guys, it should be hurting your ears. So it's amazing. So you guys, thanks for having a great day with me. We will see you tonight for movie night, and we'll see you later. Have a good one. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.